Okay, everybody, we're going to get started tonight. Thank you for your attendance. Just to recap, this is a continuing hearing on the application for special exception and variance relief from the Hamilton Township zoning ordinance filed by NOBPA LLC. Tonight's June 25th, 2024. We also have this room reserved for tomorrow night, which we anticipate will have some leftover witnesses that need to testify tomorrow that weren't available tonight. So that hearing will start at 6. The way this is going to go is the applicant is going to continue with its case in chief, however long that takes. Then the proposed objectors will have an opportunity to cross-examine the witnesses that were presented by the applicant. Also, the township will have an opportunity to do the same. Then the objectors will have an opportunity to testify. And then we're going to stop the hearing tonight at 10:30. So if we have time at the end with respect to the objector's testimony, we'll open the floor up for public comment. We'll also do the same tomorrow. So folks that have been attending these meetings and sitting on their hands waiting for the opportunity to talk and express their concerns or support for the application will be given a chance to do that. If not tonight, certainly tomorrow when we have the room reserved. So with that being said, I guess we have some cleanup items. Mr. Schutte, you have additional exhibits that you want to present tonight. Make sure your mic's on. Pull it close.
Is this on? Can you hear me?
Yeah, pull it tight. I see you got to talk right into it.
Can you hear me?
Yeah.
Okay. Yeah. Thanks, Mr. Bransky. 2 items. First, I've put onto the table there and provided to the other council and to the township applicants Exhibit 14, which, just to clean up the record as a housekeeping item, is the signed ordinance adopted on August 7th, 2023 by the Hamilton Township Board of Supervisors, which amended Section 15098 DD, which is what we've been testifying to from the beginning, and removed 15098 HH. That way the record's just complete and we have the correct ordinance in the record that we're dealing with. And then also I've provided to the board and to other council and to the township copy of applicant's Exhibit 21, which is a copy of the site plan, which I believe is in our exhibit booklet as Exhibit 6. And
Is there a difference between 6 and 21?
yes, there's very minor difference is in comments we received from the township zoning officer. There was a question as to whether or not there was sufficient screening along Kaplan Court on the left-hand side of the exhibit, on the western side of Route 94, and additional screening is shown there. And the applicant is, on behalf of the applicant, I will say that we are agreeable to adding that additional screening as a condition for approval.
Okay, is that the only change?
That is the absolute only change, yes. And then then I do have applicants exhibits 15 through 20, which will be authenticated tomorrow night by Mr. Schick when he testifies again.
Okay, so hold those exhibits for tomorrow for the traffic engineer.
And at this point, we have no further witnesses except for Mr. Schick or witnesses for rebuttal following any testimony provided by the township.
And you'll make Mr. Schick available for tomorrow's hearing at 6?
Yes, he will be here tomorrow evening at 6.
Township, any objection to those exhibits? Attorney Wolf, any objection to those exhibits?
Do you want to deal with my participation?
Oh yeah, let's
first?
get you in the case first, and then I'll ask you.
That's probably a good idea. And for the benefit of our court reporter, Nathan Wolf, 10 West High, Carlisle, at the last hearing, I appeared with my co-counsel, Bill Cluck, Attorney Cluck's 587 Showers Street, Harrisburg, 17104. We presented the zoning hearing board and counsel for the applicant and the township with an entry of appearance and identified on that document 28 households that wish to be identified as parties and objectors to the application of NOVPA, and there is one additional objector that I had identified in an email to council, and that being a gentleman by the name of E. Strayer Yake, S-T-R-A-Y-E-R-Y-A-K-E is the last name. Address is 677 Berlin Road, New Oxford. That is an adjacent property that is to the proposed Lot 1. And otherwise, we would ask that those individuals listed be identified as party objectors.
Mr. Schutte, any objection to the request of Attorney Wolf to be recognized as the attorney for and have 29 potential party objectors be recognized?
Yes, I have two objections as to just parties being entered at this time. The MPC is very clear, and it says that as to who is a party to a zoning hearing board hearing, and it's limited to the applicant, the municipality, and any person affected by the application who has made a timely appearance of record before the board. The time to make their appearance of record before the board was on March 28th, 2024. This room had over 100 people in it. Any one of them at that time could have said, I'd like to be a party to this case. Any one of them could have brought an attorney with them to say, I'd like to be a party to this case. None of them did. Therefore, this application to become a party to this matter is not being made in a timely manner, and based upon the clear language of both the MPC and Section 150-40E of your zoning ordinance, it's just not timely, and this board should not recognize the 29 individuals as parties. Secondly, the inclusion of these 29 individuals as parties severely prejudices the applicant. The applicant painstakingly presented its case over a period of 3.5 hours on March 28th. And at that time, no cross-examination was taken except by the township. And to now subject our witnesses to cross-examination and to have this hearing extend any longer than necessary because of the participation of these parties that have not timely filed their appearance before this board is prejudicial to the client, is prejudicial to my client, prejudicial to the applicant, and should not be permitted. And finally, as to the party objectors themselves, as to whether or not they are aggrieved, I'm going to reserve objection to any individual party objector being aggrieved, recognizing that many of them do fit within what would be an aggrieved status just by their proximity, by their purported proximity to the property. And so only if a substantial number, meaning the ones that are within that close proximity, choose to no longer be a party to the matter anymore, will I bring that. But I'd like to reserve that objection on the record.
So here are your three objections: timeliness, prejudice to your client, and proximity.
Great. And I also would object to any cross-examination of my witnesses or calling my witnesses as their witnesses and treating them as a cross-examination as the opportunity to cross-examine was when they finished testifying on March 28th, 2024 in the usual course.
Okay. Township, any objections to Mr. Wolf's clients being admitted as party objectors? Mr. Wolf, do you have an argument with respect to those objections?
Sure. Most certainly I do. The first of which is, and all due respect to the solicitor, unfortunately, I think that part of what had happened, and my clients were, many of them, if not all of them, were in attendance that night, and there was some confusion based on the initial comments that were made and the ground rules, so to speak, that were laid out that identified the way that the hearing was going to proceed, specifically that the applicant would present its case first, its witnesses, its exhibits and testimony, and would be subject to cross and questions from the board. Then the township would present its case, etc., and the applicant's counsel could cross-examine township's representatives. Then it would be opened up to members of the public to testify for or against the application, and specifically identifying that it was not a question and answer session, so that the applicant, its witnesses, are not going to be subject to to questions from the audience. That directly came from the transcript from March 28th. I would note likewise that the members of the public were directed to, if they were going to testify, that they were going to be sworn in. In my 20 years of experience doing land use work, I have not seen public comment be sworn testimony, and I believe that individuals who were present that night, there was no offer or question made by the board asking whether or not anybody sought party status. There wasn't a form that was placed out. I would note that there is some authority specifically dealing with South Bethlehem Associates versus Zoning Hearing Board of Bethlehem Township, 294 Atlantic 3rd 441, that talked about a party's substantial interest and their standing to appear in front of a zoning hearing board, and that individuals who appeared could later be even determined to be parties where they appeared, but it discussed specifically where there was some misunderstanding in how the proceedings began and how the public was advised to participate. I don't think anything was done intentionally, but I think that at this point there's a far greater prejudice to the due process rights of individuals under Section 10908, 5, and 6 that deal with proceedings before a zoning hearing board in the municipality's planning code that ensures the right of the public who seeks party status to have the opportunity to cross-examine witnesses on all relevant issues. But more importantly, to be heard by the board as to their basis for objection as well. And the fact is that the applicant and the end of the March 28th hearing did not rest its case in chief, and I would respond to the timeliness matter of both the cross-examination and their request for party status as that there has been nothing lost. You went to the end of that meeting that night and had anticipated the adjournment to the next hearing. It was, we were prepared to appear in April when the scheduling issue occurred by the determination that one of the board members was unable to sit and had to be replaced by an alternate, and then likewise that we would need to appear, that when we appeared in May, these individuals appeared at that time as well. We provided the entry of appearance, but we didn't take testimony. So while the timeline may look different, if we had begun the hearing in April with the presentation of our entry of appearance and the request for cross, certainly there would be no prejudice to either the applicant, the board, or the public if our request was granted then. And by the mere passage of time, without any more formal action occurring on the application, I don't think that there's any reason to believe that any prejudice would be suffered to the applicant. Moreover, that the prejudice that would be suffered by the individuals who are seeking party status is far greater in any measure whatsoever.
Thank you. Hearing the objections and the response to said objections, this board is going to overrule the objections and allow Mr. Wolf to present on behalf of his 29 clients, and we're going to recognize them as party objectors in this matter.
And to
John.
answer your original question, I don't have an objection to Exhibit 14. I assume that Exhibit 20 is going to be the subject of Mr. Brissner's testimony. And the only other question I have is, was there a written comment letter from the township that was the catalyst for the change that, to the site plan, Exhibit 20?
That's a good question. Why did you guys decide to change those?
That was it was an oral comment that Jim made to me. I think at the end of the last hearing.
No, so there was no comment letter.
Yeah.
Okay.
And yes, to
My
To,
mistake.
to,
That
Mi-
was
to Mr.
21,
Wolf's
not
point,
20.
then, if we need, I think Exhibit 21 speaks for itself. I don't know if we need, Mr. Brinzer to testify to it.
So you asked the question about 21.
I'm saying I misidentified it as 20 instead of 21.
Yeah.
Do you have no objection for it to be admitted then?
If Mr. Brissner's here and available to be cross-examined on it, no problem.
Is he here? He's right there. He's here.
Okay?
And just one more item on the overruling of the objections. I still want to reserve the right to object to individual objectors should the ones that live within the real close distance. All
Yes,
of that
that's
leave.
noted on the record.
Okay,
You
thank
still
you.
reserve the right. As they come up and testify, we find out where they live.
Mhm.
If you think they're too far from the site, you can raise your objection
I
at that
think,
point.
Mr. Baranski, that unless I misunderstood Mr. Schutte, that he was reserving the objection that if my clients who were abutters dropped out,
Yeah,
that,
that's
that if only those
yeah.
people who were remaining were farther away in terms of their location, then he would raise the objection, but otherwise he's reserving it.
Is that the interpretation, David?
Yeah,
Okay,
that's,
I understand.
that's yeah. I don't want to go into how close people live.
You don't want to do 29?
No.
Okay. Thanks. All right.
Sorry.
All right. Mr. Wolf, you're in as a party and an attorney for your 29 clients. Back to the applicant.
I have no further witnesses this evening. Request the admission of exhibits 14 and 21,
Admitted.
and we will present additional testimony. A very short piece of additional testimony from Mr. Schick tomorrow evening, and reserve the right to present evidence and testimony and rebuttal if necessary.
Okay. Township, any additional witnesses tonight? Tomorrow night? Okay. Objector, you're up.
Okay.
Jim, were you going to testify? Okay.
Good?
Yeah.
I would ask that we proceed with Mr. Bolus being subject to cross-examination.
I know you objected to that. I'm overruling that objection. Please make him available as a witness on the cross.
I restate my objection.
It's on the record.
Okay.
And I know Mr. Bolus was sworn in again. Do you want him to be sworn tonight?
Mr. Bolus, you're still under oath.
So, Mr. Bolus, you are the applicant and you are the signatory on agreements of sale that you have as to various pieces of property that make,
No, object. Mr. Bolus is not the applicant.
I'm sorry. All right. Can Mr. Bolus, can you identify the current corporate name that is the applicant?
NOBP LLC, NOBPA LLC.
Okay. And your role is the managing member of that LLC, correct?
That is correct, yes.
Okay. Are you the sole member?
No.
Okay. Who are the other members?
Private partners.
I'm sorry?
Private partners.
Could you identify
I'm
them,
going
please?
to object as it's not relevant.
Knowing who the,
Overruled.
please identify them. The objection's been overruled.
Just give me their names. We don't need their addresses, their home phone numbers or anything. It's overruled. We need
Reed Blinn.
I'm sorry, sir. I couldn't hear you.
Reed Blinn.
Okay. Is that the only partner?
Correct.
All right. When was NOBPA formed?
Last year. I don't have the exact date on me.
Okay. And now, Mr. Bolus, you, as managing member, entered into certain agreements of sale for property that makes up this project, correct?
Yes.
Okay. And there are 3 sellers that you were dealing with?
There's more than that.
Okay. Let's put it this way. There are 3 different
3 properties.
properties that you had entered into sales agreements for, correct?
Correct.
And in your exhibit book, you had included agreements that we'll start with the center part, with the Shoal Estate. Is that right?
Correct.
Now, in looking at the agreements for the Shoal Estate,
Do you have an exhibit number, Nate, so I can find it
sure.
in my book?
Exhibit, it appears to be Exhibit 3, to be in the March 28th, 2024 exhibit booklet, and that would be on page, I believe it's 62 that I'm looking for. And this is why I bring my computer. You have an agreement of sale entered into March 13th, 2023 with the Gertrude Shoal. Is that right?
Correct.
And according to the terms of that agreement, there was a requirement that settlement occur in March of 2024, 12 months after the execution of that agreement, under paragraph 7, correct?
Yes.
Okay. Now, you have, and that agreement of sale was for the entirety of the tract. Is that correct?
Correct.
Okay. Now, it was a bit of, at some point, Ms. Scholl was deceased and you were dealing with her executors. Is that right?
Correct.
Okay. Sometime thereafter, you entered into an addendum to that agreement of sale. It is dated July 10th, 2023. That's page 72 of that packet. And that extended the closing date to March 29th, 2024. Is that correct?
Correct.
And isn't it true that there is a seller's retained tract identified on that agreement?
Correct.
And that is that the buyer, namely NOBPA LLC, agreed to create an approximately 2-acre lot depicted on the new Oxford Logistics sketch plan prepared by Ratu Associates. Is that an accurate read?
That's what I see here, yes.
And it says that that lot is along Route 30 and includes the existing residential dwelling. Is that right?
Correct.
And the buyer will split off the tract in the subdivision plan for seller to retain, and the seller retained the right to decline the subdivided lot in the future at the seller's discretion.
Correct.
Okay. And that document was executed by you and the executor and executrix of the estate as well.
Correct.
Okay. Now, added to that is an addendum or endorsement that appears on page 74 of that packet, and that concerns that same piece of property, right?
Correct.
And it references, and I'm assuming that this must be a typographical error, that it says the agreement was executed March 23rd, 2022, with and the addendum and due diligence instead of 2023, correct?
Correct.
Okay. Now, it extended the due diligence to March 30th of 2024, and closing to take place on March 30th, 2025, or as agreed. That's the only change. And that addendum was signed on September the 15th of 23, correct?
Correct.
Is that the last document that exists between you and the Shoal Estate?
No, there's been a subsequent addendum.
That is not part of the record, correct?
Correct.
Do you have that with you tonight?
I do not.
Okay. So, in that document, it indicates that if all due diligence is satisfactory, township approvals are approved, a $50,000 deposit will be made in the closing agent's escrow account. Did those things occur?
As I mentioned before, there was a subsequent addendum.
Okay. Did it change anything other than the extension date?
The extension date of the due diligence, yes.
Okay. Did it modify the 2-acre lot?
No,
Okay.
not to my knowledge. I don't
All right.
recall because I do not have it in front of me right now.
So what's due diligence pushed out to now under that new addendum?
August 30th.
August 30th,
Mm-hmm.
2024?
Correct.
Okay, thanks.
And are you able to provide that to make sure that the record is complete?
Certainly.
Okay. So, are you familiar with the plans that have been submitted thus far on this application?
Yes.
Okay. And can you, I'm going to draw your attention to the exhibit that we've just been handed this evening, number 21. Do you have it in front of you? Do you have that in front of you now, sir?
I do.
Okay. Can you tell me where the 2-acre lot that is supposed to be depicted on the New Oxford Logistics sketch plan prepared by Ritu appears on that plan?
We did not show it on the plan.
Okay. Now, can you tell me, it references the agreement, or the addendum that we talked about, references a 2-acre lot that includes the existing residential dwelling along Route 30. Can you tell me where the existing residential dwelling is along Route 30?
I don't have an exact location of it now.
Would you agree with me that it's approximately the same location as the site driveway appears opposite Stanley Drive?
No.
No. Okay. How far away from Stanley Drive is it?
I do not know.
But you know that it's not there. Okay. So, is there any provision made for a 2-acre lot for the Shoal Estate to retain anywhere on the 67-acre tract that they were selling?
Not shown on this plan.
Right. And in fact, the plan itself shows existing lot 2, 67.58 acres, on the page 1 of 3, and on page 3 of 3, proposed lot 2 is 123.69, and likewise does not show a retained 2-acre parcel, correct?
I'm sorry, repeat that again?
I said neither on the existing conditions page of the sketch plan page, which is 1 of 3 of applicant's exhibit 21. There's no 2-acre lot on that where it says the existing lot 2 is 67.58 acres. And if you turn to page 3 of that packet, where it shows the sketch plan as well, that does not show a 2-acre retained lot there as well. Is that right?
Is that a statement or a question?
I'm asking whether you agree with that statement, that that 2-acre lot does not appear on either one.
Yeah, it's not shown on this particular plan, but we do have copies of other plans that do have it on there. I remember
Okay.
that from when we first started this.
So, my question for you, Mr. Bolus, is if that 2 acres is where the agreement provides for, and you said that you're not exactly familiar with where that house is. Do you know the property address for that house?
No,
Okay. Would you agree with me that it may be 6298 York Road?
I do not know.
So, if I told you that that house was across from Stanley Drive, would you have any basis to say otherwise?
Yeah, if you say it's there, I can't object to that because I do not know. And the Stanley Drive roadway was put there at the request of the township and PennDOT.
Point of order, Mr. Baranski. It's very difficult to respond to.
You guys pull that mic close to your mouth like I'm doing here. You got to almost put your lips on it for them to hear. We'll sanitize them later.
My
All
lips
right.
to the microphone.
So, Mr. Bolus, you said that there were additional versions of the plan that show that 2-acre lot. Have any of those ever been submitted to the township?
No, they're original sketch plans.
And these are revised sketch plans?
Correct.
Okay. In 2023, when you appeared in front of this board and had a different plan, were those part of that application?
Part of what looked?
Did the sketch
application?
plans at that time, from 2023, did they include that lot?
When we first submitted the plan back in August?
Or July of
July?
last year?
Yeah, I have
Does that
no
sound
idea.
right?
I have no idea.
You don't know if that lot was on there?
I do
right?
not, no.
Okay, all right. Has the seller of that property seen the current version of the sketch plan?
Yes.
Okay.
I've sent it to their council.
Okay. So, and we have your agreement to provide the addendum to be part of this record, correct?
Certainly.
Okay. The Lawrence property is the next one I want to ask you about.
Yeah.
Before we go on to that contract, can I ask a question? Are you still intending to convey that 2 acres to the seller? Or a better question, is the seller still intending to retain that 2 acres?
Well, it hasn't been a subject until tonight, so yeah, I'll refer to them tomorrow and find out what they intend to do.
Speak into the mic.
His response was that they hadn't talked about it.
Let him speak for himself.
I'm sorry. I just was letting the.
They have a
public
copy of the
hear.
plan. They have not seen it yet. They haven't, their council has not commented on the 2-acre plan, 2-acre savings, or piece of land.
But that intention in the contract to have the seller retain it has not been removed from the contract by any of the addendums, correct?
Correct.
Okay.
Okay. So, similar question as to the agreement that you have with the Lawrences. And this is likewise, Ed, as part of Exhibit 3, and we're starting off at page 46. And as my computer catches up with where we are, you have an agreement of sale between the Lawrences and NOBPA that was entered into in 2023, correct?
Correct.
And that was for 64.62 acres, more or less, correct?
Yes.
Okay. And that provided that settlement was to be within 12 months of the date the contract had been executed.
Correct.
And the contract was executed on, I believe, actually it doesn't have a date at the top, but it was March of 2023, is that right?
I'm sorry?
March of 2023
March 2023, what?
is when the agreement was signed?
Yes.
Okay. And there was a deposit provided for that, correct?
Correct.
And then an addendum on June 30th with the Lawrences that provided closing to occur on or before March 29th, 2024, correct? On the addendum.
Your question again?
The closing as provided by the addendum that you entered into with the Lawrences on June 30th, 2023, closing was extended out to March 29th, 2024, correct?
Yes.
Okay. And that likewise, that addendum has a seller's retained tract component to it. Is that right? Paragraph 3, this is page 57 of the packet.
Correct.
Okay. Now that proposed tract was to be adjusted a parcel up to 10 acres in size, provided it is advantageous for the sellers, namely the Lawrences, to create a parcel this size, as the buyer is not interested in the parts of the property along the creek owned by sellers. Did I read that accurately, sir?
Correct.
Okay. There was a second addendum to the agreement of sale. The date is blank. This is page 59. This says July 2023, but the date itself is blank. But it identifies the March and the June 2023 agreement and amendment. And it identifies the whereas clause to be amended to reference the fact that they were selling 64.62 acres. Is that right?
Correct.
Okay. And you were identifying the correct tracts in that, and otherwise it was still the same agreement subject to the same conditions. Is that an accurate statement? If it's not,
We can probably shortcut some of this. All of these agreements speak for themselves. I mean, all the terms are within the four corners of the agreement.
Is that objection?
It's an objection or just a desire just to say, we'll stipulate that these agreements say what they say.
Yeah.
No reason to read them.
I understand what Attorney Wolf's getting at. He wants to see if those, correct me if I'm wrong, you want to know what is happening with respect to those retained lots because it could affect the layout of the plans submitted to us.
It most definitely does, and the plans that we've seen heretofore do not depict that lot.
Okay. Let's not go word for word
That's
over
fine.
the contracts.
Which lot are you referring to?
This is the Lawrence property.
Yeah, lot 4 is 10 acres.
I-
Did you miss that? Lot 4 is the 10 acres retained by the Lawrences.
So, are you referring to Exhibit 21, the page 1 of 3, that depicts existing Lot 4 as 10 acres?
I'm not aware of what you're talking about, but
Well, where are you referring to 10 acres, sir? What's the reference that I
it's on
wanted
the
to
plan,
draw
on
our
the
attention?
plan we just handed to you.
Right. And it says EX Lot 4, 10.0 acres, right?
Correct. Subject to negotiation if they want to retain the lots of the extra land around the wetlands.
Now, the 10 acres that are depicted right now include a portion of the warehouse, do they not?
What does it say 4 on here? Right. Right, but then this goes up to here, right? Yeah.
You guys have an answer? Do you have an answer?
I'm sorry, repeat the question again?
The question was, sir, you indicated that, yes, there is a 10-acre parcel. And-
Proposed 10-acre parcel.
Okay. Can you point to me where on the plan there is a proposed 10-acre parcel?
It's on the other plan.
I'm sorry?
It's on,
Page,
I don't know, what's this, 1 of 1? 1 of 2? 1 of 1.
now, is that the lot that shows lot lines that include the middle of the warehouse, which with what looks like a Z across them?
Could we have a quick second? Go over the plan together?
You want to go off the record?
Yes, please.
Take 5 minutes.
Thanks.
I'm going to just, Mr. Baranski, I'm just going to note a quick objection to the witness not being able to answer the question without the assistance of his counsel. I've been withholding that, but it's been going on.
Yeah,
every
but
question.
here's the thing. The owner probably is not the guy that you want to ask these questions to. It might be the engineer that drew the documents, which he's there also. So he's probably the better guy to ask where these lot lines are.
We'll see. No. Thank God.
Don't get rowdy. Guys have been behaving well so far. We appreciate it.
It says proposed. What the hell does he want?
It's only 2.5 acres. This says 10 acres.
Well, it's still proposed. I mean, it doesn't matter. I mean,
You'll have.
So we're seeing it shall create approximately a 3-acre parcel, and then you agree to it, make it a 10-acre parcel.
No, well, that's because it was wetlands, and we said if we wanted it and we didn't need it, that I would throw it in.
We need it now,
Let's see where this
Okay.
so,
Stay tuned.
Well, it's an ambiguity between the contracts. I mean, that's something that,
not really, it's an ambiguity.
How you holding up?
well, we have equitable title to it. It's just, it's proposed, for Christ's sake. I mean, I'm just going to sit here and pick apart the whole damn thing one night? The fuck?
You're gonna need
Oh, I will.
You guys good?
Yeah, we're fine.
Mr. Wolf, are you good?
I'm ready.
All right, let's get to it. We'll go back on the record.
This is fine.
I think there was a question that needed an answer, and you needed a minute.
Yeah, it's proposed. It's proposed 2.56 acres. There's some wetlands there. You know, we're showing is the difference between the two plans. One, if we don't need the wetland area, you know, we were going to offer that to them, just like I did with the Staubs up the street, where I said I would buffer their property and we move the driveway. I'm trying to accommodate everybody, so that's where it's at, and it's proposed, and it's early in the plans, and this is basically a sketch plan for special exception. So it's subject to change, obviously, as it says proposed on the plan.
Mr. Wolf?
So I just want to make sure that I understand. Right now, you're showing 2.56 acres as opposed to a 10-acre lot. You haven't depicted the 10-acre lot that's referred to in the addendum to the agreement of sale, but there could be one in the future.
As I mentioned, there's a subsequent addendum to the agreement of sale that'll address that.
Can you, okay. Can you show us, do you have the subsequent
I do not.
agreement?
No, and we'll put that one with the other one when we get it to you.
I'm sorry, I couldn't hear you either, sir.
We'll put it on the, we'll include it with the other one when we send it up to you, the other addendum.
Okay. And I recognize that the natural tendency might be to look towards me as you're answering. It might be easier if you use Mr. Bristner's microphone as opposed to Mr. Schuette's, just so that you're facing me when you're answering. That microphone will pick you up a little better then.
I'm good with this one.
Okay. All right, folks. All right, folks.
Settle down, people.
So, do you have a new agreement with regard to the Lawrence's that is not of record, is what your testimony is?
Yes,
Okay, and that you're agreeing to provide that
correct.
tomorrow night to complete the record?
I won't have it by tomorrow night.
Before we close the record, if you intend to submit additional exhibits, we need to know that, and it will have a strict deadline for submittal of that.
And what is the strict deadline?
Well, we'll come up with it.
Okay. Yeah, because I'm in town through tomorrow night, so
Okay.
I'll have access to it here.
But your testimony tonight is that reservation in the Lawrence contract of a 10-acre holdback by them, or proposed holdback of 10 acres, is modified in some addendum. Is that right?
Again, it was negotiated. I have to go back and read it. I can't testify to that right now without reading it.
So you're not 100% sure if that was
That is
modified?
correct, yes.
Okay.
Okay. So, if I recall your earlier testimony, NOBPA was formed in 2023, correct?
Somewhere around there, yeah.
Okay. Your agreement that was between the Lester E. Myers Trust and NOBPA has a date of July 2021. Is that correct, sir? And I'm looking at page 32.
There's no numbers on this thing.
It is the first page of Exhibit 3 in your exhibit packet.
Yes, that was modified.
What was modified, sir? I'm sorry.
Been subsequent addendums to that as well.
But the original agreement was between NOBPA LLC and
No,
the-
my apologies. NOBPA LLC was created back in probably 2021, shortly after this was done. I was under the impression that David had done that, but it was another attorney that was using it at the time. So it goes back to 2021. I'm sure you can find that.
Was it in place prior to you entering into these agreements of
Yes.
sale?
Yes. That was a yes.
I heard you.
All right.
Okay, I just want to make sure.
So the agreement with the Myers, I'll try and go through this a little more quickly. That was for 51 acres, and that was to occur with settlement to be within, I apologize, I believe that was in 12 months initially as well, and then that was extended, correct?
Settlement's right here. Yes, 12 months.
Okay.
Subsequently amended.
And that one was amended to be through settlement to go until October 30th, 2023. And there was a change in terms for that. That begins on page 44 of that packet. And that document was executed in May of 2023, right?
Correct.
And that one included the seller retaining a commercially zoned lot on Route 30 that would include 10 acres of land. And that 10 acres of land would be determined within 90 days of a completed survey. Did I accurately describe that provision?
Correct.
Okay. And you had closing dates extended out to March 16th, 2024, with an option with an additional deposit. Was the additional deposit paid?
No.
Is there an existing agreement of sale between you and between NOBPA LLC and the Myers Trust today?
Yes.
And does that agreement also have the 10 acres retained by the Myers Trust?
I'm not aware. I don't know.
Okay. Do you know who David Bodie is?
Correct. Yes, I do. Know of him. Don't know him personally.
Okay. And Mr. Bodie's the broker who currently has the property listed as for sale for the Myers Trust. Is that correct?
I don't know.
Okay. Well, it's a property that you have purported to have an equitable interest in. Am I
We
correct?
do. Yes, that is correct.
Okay. When did you execute the extension agreement on that?
I don't recall.
Was it before or after the hearing that was scheduled here in May?
I don't recall.
Okay. So, would it surprise you, Mr. Bolus, to if I told you that in an email communication with Mr. Bodie, he indicated that that property is not under contract?
I'm going to object on all of this line of questioning. It's not this board's job to determine title.
Oh, it is very much this board's job to determine whether there is.
May I finish?
Actually, sir,
Hey,
it is very much
Let's,
the board's job.
you guys have been civil thus far. Let's not,
May I finish?
let him finish, Mr. Wolf.
Is not this board's job to determine title. Secondly, whether or not this property is under agreement or not depends upon the terms of the agreement itself. Whether an additional $50,000 deposit was or was not made does not terminate the agreement. It goes to the actual agreement. And what Mr. Bodie may have said in a hearsay email to Mr. Wolf does not determine legally whether or not this property is under agreement or not.
Let me ask
there would
this
be
question.
a default provision.
Is there an agreement of sale in the exhibit book?
Yes.
And is that agreement of sale in the exhibit book still effective?
Absolutely, yes.
And Mr. Wolf, why do you think it's not effective?
Because the terms of the agreement say that settlement is to occur on or before March 16th, 2024, with the option to extend until March 16th, 2025 for an additional $50,000 deposit, which shall be applied to the purchase price. And we have just heard testimony from Mr. Bolus indicating that that $50,000 was not paid.
And the remedy for that $50,000 not being paid is not a termination of the agreement without first a default notice being provided by the other party, which has not happened. So there's nothing in the agreement or these facts that show that this property is still not under agreement and the applicant is still not the equitable owner of the property.
Other than, I'm directing this to Attorney Wolf, other than the email from Realtor Bodie, do you have any other indications that the agreement of sale proffered as an exhibit by the applicant has been terminated?
Do I have any?
Do you have any evidence, other than the email you're relying on, that this property is not under an agreement of sale?
Well, we are more than 60 days of the period of time in which the default would have occurred, which would have been March of 2014.
Yeah, but you're interpreting the agreement. I'm asking, do you have any independent evidence that it's not under, any independent evidence that it's not under an agreement of sale to rebut the applicant's testimony that it is?
Other than the verbal statement from the broker to me, no.
Okay. Let's,
Then I object to
yeah,
the line of
sustained.
questioning as-
Sustained on
Thank
that line of questioning.
Thank you.
If I can ask, I'm not allowed to ask him whether he's in agreement with the,
The applicant's testimony is it's
Yeah.
still under an agreement of sale.
And further to that, the agreement speaks for itself. If there's other
Okay.
documents that he wants to submit, such as a default notice, termination notice, anything like that, then that's fine. But the document speaks for itself. The property's under agreement, as does Mr. Bolus's testimony.
and my response to that is that the board certainly has to determine whether or not the applicant has an equitable interest in the property. If the documents from it on their own.
You've brought all of that to the board's attention by
But-
what you've brought,
May I finish?
what you brought out.
And my point is that unless the applicant himself has another document that shows that there has been some agreement, the document by its own terms expires if things have not occurred. And the applicant, it's the applicant's obligation and duty to demonstrate that he has an equitable ownership interest. He went to the trouble of providing these exhibits in its initial submission, not for the sake of doing it, but because if he didn't do it, he can't demonstrate that he has standing to move forward with the application. If he doesn't have a valid agreement of sale, and we have to take his word for it tonight that he does still have a valid agreement of sale, then we are relying on solely his statement, and it's virtually impossible to rebut. But the documents themselves have terms that have expiration dates if certain things don't occur, and the applicant by his own testimony said that thing didn't occur.
And you can make that argument at your closing argument, that you believe with respect to at least that one contract that the applicant doesn't have the authority to present a case on that.
And I believe my objection's already been sustained on this, and he's testifying under oath, and
Well, he didn't
If-
didn't testify. You represented
Right.
that there was a valid contract.
but I mean, he represented that it's not terminated. He testified that it's not terminated, and the agreement speaks for itself. The agreement doesn't automatically terminate if closing doesn't happen by closing date. That's
Listen,
just
guys,
not what it says.
we're not making
Okay.
a finding of
Okay.
fact.
Thank you.
We understand your concern about the
Yeah.
agreement.
All right.
It'll be taken under consideration.
And I have one clarifying question. I promise it is not. Is there another document that exists between you and the Myers Trust?
That's my knowledge.
Okay. Is the 10-acre retained portion, the commercial lot, depicted on any site plan that has been presented to the township?
It hasn't been determined yet.
I'm sorry, what hasn't been determined?
Hasn't been determined the exact location of the 10 acres. We figured we'd do that during the land development process. This is just a special exception. So there's a lot of things that we don't have done yet and haven't identified yet, only because we're not there yet.
And just
It's
to be-
one step at a time. We're not going to develop the whole property unless we get the special exception. I think that's pretty clear.
But just to be clear, the terms of that agreement did say that within 90 days of the addendum being executed in May of 2023, not May of 2024, but May of 2023, that's when the 10 acres of land were to be determined, correct?
I don't believe that's what it says.
Seller shall also retain the commercially zoned lot on Route 30, which will include 10 acres of land to be determined within 90 days
Of the completed survey. There's no completed survey.
All right.
Let me ask a quick follow-up on that. Is it Myers? Have the Myers indicated to you is it Myers?
The only concern I have is that would be no less hearsay to elicit that answer than it would be for their representative, Mr. Bodie's statement to be a record.
All right.
Mr. Bolus, how many warehouse developments has NOBPA attempted to develop prior to this one?
We have approximately $3 million in development right now.
I'm sorry,
We have approximately 3 million square feet under development right now.
where is the location of the other property?
I don't think that's germane to this conversation,
I'm asking.
honestly. I really don't.
The questions, well.
Well, how would that be relevant? Take this.
Yes. One quick
No,
question. I mean, it's one clarification here is that NOBPA is a single purpose entity, and this is its only project. But if we're referring to other entities that Mr. Bolus is involved in, I think that's a fair question. As these are fair questions.
And I'll clarify the question. I'll rephrase it. Mr. Bolus, are you involved in any other entity that has developed warehousing in the past?
Correct, yes.
Okay. Can you tell us what the name of that entity is?
There's several different entities that I'm currently working on right now, and we have one that's been, that closed a couple years ago.
Okay. Can you? I don't want to make this.
But I've been primarily a residential developer for the last 35 years.
Okay.
Same process.
Well, can
I've
you?
developed over 3,000 building lots.
Okay. How many warehouses have you developed to land development approval and construction?
I don't construct them.
How many warehouse developments have you obtained final land development approval for?
Currently in the process of over 3 million square feet.
So the answer is none.
That's not what I said.
Well, the question was, how many have you developed to the point where you have gotten final land development approval?
Several.
Can you identify one of them for us?
Answer.
Yes, Elkton, Maryland. Sold to Estes Trucking.
Okay. And that has received final approval for construction?
Correct.
And did it receive final approval for construction before you sold the project?
Correct.
And you said it was sold to Estes, Maryland, or to Estes in Elkton, Maryland.
Correct.
And how large of a warehouse was located on that site?
Wasn't really determined at the time we sold it. I did the annexation, the rezoning of the property, and then they were going to possibly use it as an IOS or additional storage facilities.
Okay. I thought you said you had approval for land development when you sold the project.
It was.
And you said that the size of the site was not developed, or was not determined at that site?
That's correct. The development that I was referring to was the annexation and the rezoning of the property. And then we took it through land development. to the point where Estes took it over.
Is there a constructed warehouse today?
I don't know. I haven't been down there.
How long ago did you sell that?
18 months.
Okay. And do you have an address for the property?
No, I don't.
Okay. Do you have any other facilities that you have
I already
developed?
said I did. I'm developing several. I've over 3 million square feet right now. I'm developing, under development.
What county?
I'm going to object on just basic relevance of this. I mean, the application speaks for itself. No, the application speaks for itself, and the only relevant information this board should be interested in is the whether or not the criteria set forth in the zoning ordinance is being satisfied on the plan and application before it now. This has nothing to do with other projects, nothing to do with other experiences, nothing at all with that. Everybody does different projects, everybody does different projects to different points. None of that has anything to do with the set of criteria that this board needs to focus on. Now, this is all red herrings, and I think that unless Mr. Wolf's going to ask a question that relates to any of the criteria that this board needs to determine whether or not a special exception should be approved on, I'm going to object to any further questions outside of that set.
Mr. Wolf?
Well, the reason that for the questioning of this, going down this particular road, has to do with the fact that on direct examination by his attorney, with the exception of asking if he retained RITU for civil engineering and traffic engineering, something that's easily verifiable, all of the other questions that deal with the application itself is asking whether or not the applicant would be willing to abide the ordinance requirements as a condition of approval. So we are, again, relying on what Mr. Bolus is representing to the board is what he is willing to do, and I'm trying to get into whether or not he has any experience in developing warehousing and distribution centers, because some of the basic things that he has agreed to, it would be helpful to know whether or not he has knowledge as to what the implications of that agreement are.
And they would be, if this board grants approval, they would be conditions for approval and would be required to be met either as performance conditions, which should be enforced by the township as any other ordinance would be enforced, or need to be included within the land development plan when approved. Again, nothing about anybody's experience, other projects, any of that has anything to do with the conditions that need to be met by, I mean, they're objective conditions. They're either met or they're not. And some of them are performance conditions to which we need to have a condition for approval agreed to by the applicant, which was taken care of through that line of testimony during direct. Again, I object to any further questions about experience or other projects.
Well, your objection on this particular line of questioning is sustained.
If I may,
Move on.
can I
Move
respond
on.
to the,
I
I'm-
sustain the objections. Go on to your next question.
it goes to his credibility. But,
On to your next question.
all right, so, Mr. Bolus,
Yes, Mr. Wolf.
so, the ordinance 150.98.dd subsection 9 says that talks about the repair and performance of vehicle service within an enclosed building completely. You understand that that is a requirement of the ordinance?
What's he talking about?
Which number, Ms. Wolf? Number 9?
Number 9.
So what's the question?
That, I asked the witness if he was familiar with that requirement in the ordinance.
I think, again, the ordinance speaks for itself, and he already testified to that.
Baranski, this is, it's becoming pretty difficult for Mr. Schutte to not only counsel his client on how to answer every question, but then to interrupt my question saying that every piece of evidence speaks for itself.
Well, I mean, that's a simple question. Does he know it's in the ordinance or not?
Yeah, I just read it. Yeah, it's right here.
So,
Okay.
yes.
Yes.
That's a yes.
Okay, so, are you familiar with warehousing operations and requirements of truck drivers in terms of pre-trip inspections?
Again, I don't construct these buildings, I develop them.
Do you understand how they operate, sir?
Yes, I do.
Okay. Are you aware of the federal requirements on tractor-trailer drivers to do pre-trip inspections before they leave the site?
That's assuming this is a warehouse and not a manufacturing facility.
It's either a yes or no. You either know about it or you don't. Yes or no.
Yes?
Was the answer yes?
Yes.
Okay. So, are you aware, sir, then that if a truck driver finds a malfunctioning component on his truck, he can't take it out onto the road until that repair is performed? Yes or no question, sir?
No.
No, you're not aware of that?
Vaguely aware of it. Again, I don't build these, I don't operate them, I develop them.
Okay, so
We will comply with whatever is in the ordinance.
where on your sketch
So
plan?
you can, I mean, if you're going to keep asking questions about the stuff I'm reading right in front of me here, I think it's a bit time-consuming for all of us. Sorry. Don't mean to lose my temper here, but this is getting a bit, I mean, you're going after you're personally attacking me, you're going after this stuff. Get to something relevant, okay, so we can find out what you were trying to accomplish here besides stop my project.
Okay. How about, you were asked, if the application were approved, would you agree to a condition that all vehicle service and repair activities be conducted with a completely enclosed building?
If it meets the ordinance, yes.
You answered yes. Where on your sketch
If
plan?
it meets the ordinance, yes.
Where on your sketch plan do you propose to do vehicle repair or service?
It's a sketch plan. Why would that be on a sketch plan? You know this as well as I do, Mr. Wolf.
Would know that your sketch plan should be able to demonstrate that you can comply with the ordinance.
We will comply with it during the land development process.
Is that a no? There's nothing on your sketch plan to provide for.
No, there's
Sure.
not at this time.
Okay. That's a no.
But it will be complied with when we get to land development process, along with everything else that he's been asking me questions about. It's all pre-development questions.
All right. Mr. Bolas, specifically subsection 13 of the governing ordinance dealing with truck terminals, warehouses, that we are here under, that your application was filed under, provides that a site plan be submitted to the Township Zoning Hearing Board for use at the hearing during which the project will be reviewed, that shall show building dimension and placement, internal circulation, landscaping, and all other pertinent design information needed for a complete review of the project. Does your plan demonstrate that you can comply right now with subsection 9?
I'm going to object again. I'm going to object to this line of questioning in that the location of vehicle repair must be indoors. The plan shows a building. There is nothing that the site plan would need to show on this other than that there will be no vehicle repairs being done outside of a completely enclosed building. That's what the ordinance requires. If vehicle repair needs to be done, it will be done in compliance with the ordinance. Again, that is a performance standard. It's not something that is shown on a plan.
What? I'm sorry.
You're objecting to what? The question?
I'm objecting to the question in that he's asking for conclusions of law, and he's also likely asking the wrong witnesses too, but he's asking for conclusions of law on what does the ordinance require, what does federal law require, and And very simply, anything that says shall be conducted is a performance standard, which is not something that's shown on a site plan.
I think the question is, if you have a truck that breaks down on site in the course of doing warehouse work, and
It will not-
and it needs
and-
to be repaired, because apparently there's a federal law that says you can't leave the site with a malfunctioning tractor trailer, and it has to be repaired indoors under Section 9.
You would,
Where's that going to happen? And it has to, and I think the point is, it better show on the plan where that's going to happen.
but I think the answer is, I mean, I don't want to speak here, but the answer is there's a building on the plan.
Are we getting testimony from Mr. Bolus or Mr. Schutte?
My point is that the question's about a performance standard, to which there was an agreement that this can be a condition for approval. That's how this works.
Is that question that I just asked better left for the engineer?
What's that?
Is that question that I just asked better left for the engineer to answer?
Possibly, yes.
Okay.
Yes.
I will reserve that question for the engineer when Mr. Bolus is done. So write it down, because I'm coming back to it. Got it? Mr. Wolf.
So, Mr. Bolus, are you anticipating having multiple tenants in this property or a single tenant?
It's too early to tell.
Okay. And actually, let me clarify that question, because when I refer to the property, that could refer to both buildings. Within the Lot 2 building, the proposed 621,000 square foot warehouse, do you anticipate that building being for one tenant or two?
That has not been determined yet.
Okay. Now, if it is for multiple tenants, do you have any provision for gated access?
Hasn't been determined yet.
Okay. So if you would need to provide gated access, would that gated access include a separate circulation plan?
That hasn't been determined yet.
Okay. So do you have a detailed truck parking and staging plan?
If that's a question better left for the engineer, say so.
Yeah, I'd like to refer to my engineer on that, but I'm sure, again, that probably has not been determined yet.
Okay. Does your plan have any provision for drivers to remain on site if they are out of service hours while they're operating their truck?
That hasn't been determined yet.
Are you aware of Act 124 of 2008 that, while similar to the township's ordinance under subsection 10, actually restricts the idling of a vehicle in excess of 10,000 pounds for no more than 5 minutes as opposed to 10 minutes within an hour? Are you familiar with that, sir?
We will be in compliance.
Were you aware of that requirement?
We will be in compliance. I mean, what's so bad about that? I mean, we're going to comply with the law. That's what we're
Guys,
doing. That's what we're still doing here, complying with the law.
I better address the audience. We can't have the
Thank you.
who and han in the background. Let's try to get through this.
Mr. Bransky, would you direct the witness to answer? If he didn't
I
know
forgot
about
what
it, he
I
didn't
forgot
know
what the
about it.
question was. What was it?
Was whether or not he was aware of Act 124, the Pennsylvania diesel-powered motor vehicle.
Are you aware of the act?
Was
No,
he aware?
I don't build and I don't own these.
No,
I
he's not
develop
aware
them.
of the act.
Thanks, John.
Would it be fair to infer then that your intention would be to sell this plan if it were approved?
Correct.
just a moment to confer with my co-counsel.
Let's go off the record for 2 minutes. I didn't hear you. What time is it, Christine? 10:30? Is it? Feels like it.
Just one last thing.
What? Hold on a sec. Let's go back on the record.
Okay. All right, folks. Just one last thing, Mr. Bolus. This is the last thing I'll ask you about tonight. You testified that you incorporated NOBPA in Delaware because it's a foreign entity, right?
Not sure whether I identified that, but yes, that is correct.
Okay. And your testimony is that it was incorporated or formed in 2021?
I don't recall, but that's approximately the date. I don't have the exact date.
Okay. So if I told you that the Delaware Department of State official website lists June 23rd, 2023 as NOBPA's incorporation or formation date, would you have any reason to disagree with that statement?
Yes.
Okay. Do you have any other documentation?
I have to go back and look at, I'll have to dig out the original documents to see what the exact date was.
Okay. And do you have any reason to believe that as a foreign registered corporation that the Pennsylvania Department of State's Corporation Bureau's record of June 27th, 2023 of that entity having been formed in Pennsylvania, do you have any reason to believe that that information is incorrect?
I have to go back and check the records.
Okay. And again, that was June 27th, 2023. So, just to be clear, your agreement with the Myers Trust was entered into 2 years prior to that. Is that right?
Again, I have to go back and check the records.
Well, as to that, the exhibit that you were testifying to earlier tonight, you did agree with me that that was executed in 2021, July, correct?
If that's what the agreement of sale says, yeah.
Okay. I have no other questions for Mr. Bolus. Can we take a brief break?
Hold on a sec. Anything from the township?
I'll have redirect, but I'd be happy to take a 5-minute break before we do that.
5-minute break for bodily functions.
guy has their own. Well, they didn't introduce the exhibit from last year. They didn't introduce the clear. So I'll tell you, the one thing that I do like to do is that's when they gave them the right numbers. That's it. Yeah, that's because the township hadn't given them the correct information. Yes, ma'am. I'll tell you what. May I ask your name? Hi, Rose Lansing. Are you one of the folks that is in our group? I didn't. No, when they call for public comment tonight, the reason I was asking that is, go ahead. Look at it. Make money. I agree with you. I do too. I don't believe me, my friends think definitely right. No, believe me, ma'am, I understand. I don't want to be discourteous to you. They will open up for public comment. They'll have an opportunity to say your piece. I urge you to do that. I just need to get off. Oh, be brave. Be brave. Do it. Okay.
Hello?
Aye, Skip. Thank you.
All right, let's try to get back into some state of decorum. Again, I thank everybody in attendance for your cooperation. I think we left off, we were coming back to you, Attorney Schutte, for redirect, and you asked for the intermission. So the ball is in your court.
Thank you. Can you hear me?
Yes.
All right. Mr. Bolus, just following up on a couple of questions that were asked you by Mr. Wolf. First, as to the formation of NOBPA LLC. Am I correct that NOBPA LLC's only assets are these purchase agreements and the applications that have been submitted to this township?
Correct.
And to the extent that NOBPA LLC was not formed prior to, I believe it's the first purchase agreement, the 2021 purchase agreement being entered into, it has since been formed, correct?
Correct.
And you've entered into subsequent amendments with the Myers Trust since the formation of NOBPA LLC, correct?
That's correct.
And no time has the Myers Trust asserted to you in any way that it is deemed this contract to be void or voidable due to the fact that NOBPA LLC was not formed in Delaware prior to entering into the initial purchase agreement.
Correct.
And as we said earlier, am I correct that subsequent agreements have been entered into ratifying the original purchase agreement?
Correct.
Okay. With respect to the Lawrence purchase agreement, am I correct that you testified that there will be that there was an additional, to your knowledge, there was an additional addendum after the addendum extending closing date to I'm sorry, after the
March
addendum,
25.
March 2025, correct?
That is correct.
Okay. Going back to the and with respect to the Lawrence purchase agreement, your testimony is that there was an additional purchase agreement beyond the one that extends to extends closing to March 30, 2025.
That is correct.
And you'll be able to access and provide copies of those addendums or amendments to this board in due course, correct?
Correct.
And then finally, with respect to the Gertrude Scholl purchase agreement, am I correct that currently under the not the Scholl agreement, the I'm talking about the the first agreement, the Myers purchase agreement. With respect to the Myers purchase agreement, your testimony is that the last amendment we have is the one that extends to March 16, 2025, provided that an additional $50,000 deposit be made, correct?
Correct.
And you testified that $50,000 deposit has not yet been made, correct?
Correct.
Okay, have you received any written notice of default from the representatives of the Myers property?
I have not.
And have you received any notice of termination from the Myers property?
I have not.
Have you received any demand to close from anyone in the Myers property?
I have not.
Have you received any complaint in specific performance from anybody at the Myers property?
I have not.
With respect to the property that would be reserved by the property that would be reserved by the buyers under each of these agreements, am I correct that those discussions and the location of those properties is a point of discussion and likely a point of a future amendment to these purchase agreements?
Reserved by the sellers.
Reserved by the sellers, but that's a point of negotiation and likely to be resolved by future amendments to these agreements after the development plans have been a little bit more solidified.
That is correct.
And as to the special exception, you don't want to put those areas yet on the special exception plan. You want to put them where they match with the special exception plan and still comply with the ordinance, correct?
That is correct.
And your intent to do that would be at land development plan approval process and still comply with all the relevant portions of the zoning ordinance, correct?
That is correct.
And finally, as to the conditions for approval you agreed to, specifically 15098 DD9, correct, that you do not intend to operate this building, correct?
Correct.
And as a result, there will be a condition placed upon the property, or placed upon the approval that the provisions of 15098 DD9 would be complied with, correct?
That is correct.
I'm going to object to the leading nature of the questioning. I recognize we're trying to get through it, but I have held off on objecting to this point. Perhaps we could have a non-leading question.
I'll soon be done.
Overruled. Keep going.
And would it be your understanding that if there would be a disabled vehicle, that vehicle could be towed off-site,
That is correct.
or that a enclosed building or a portion of the building could be used for vehicle repair?
That is correct.
And finally, if there would be 2, 3, 4 tenants in any of these buildings that, based upon tenant requests, would you come up with revised locations of where gates may be, or positions of where the access would be, and still yet be compliant with the ordinance based upon tenant requests?
Yes.
I have nothing further.
Does the board have any questions for Mr. Bolus? Okay. Mr. Wolf, you want to cross-examine the other witness?
I imagine that means that I... Can you hear me? Okay. I'll sit closer. So, I imagine that you're not giving an opportunity for recross.
2 minutes.
Okay. Mr. Bolus, as a developer, you're familiar with the concept of specific ordinance criteria, right?
Yes.
And do you understand that it's the applicant's burden of proof for specific...
Objection. He's asking for a conclusion of law.
I'm asking if he
I haven't
knows...
heard the whole question yet. I don't know what he's asking. Let him finish.
I'm asking if he understands the relative burden of proof attendant to an applicant for special exception.
That's a good question. Overruled.
Go ahead. Do you understand the burden of proof upon an applicant in a special exception proceeding?
Yes.
And do you know that you have the affirmative duty to present substantial evidence that you comply, that your plan complies with the specific ordinance criteria?
Yes.
I'm going to object to the question, move to strike, in that, again, it is asking for a conclusion of law, and secondly, that's not even the correct statement of law. It's not the plan, it's the application and presentation and evidence presented to the zoning hearing board to satisfy the criteria.
Your objection's noted, but he already answered.
Mr. Bolus, your current plan doesn't provide for any gates or staging areas depicted on your plan, doesn't it? It does not, correct?
That will be addressed during the land development process.
Okay.
Thought I answered that.
And you understand that this board wouldn't have the ability to review again whether or not you can comply with the provisions of the ordinance once it gets to land development, right?
Again, I think he's asking for a conclusion of law as to what this board has the
Sustained.
authority to do.
Yeah, sustained.
Thank you.
I'm making the point that we won't.
Sustained. Go on to your next question.
Nothing further. I ask that Mr. Bristner be subject to cross now.
I repeat my objection as to the cross-examination of witnesses that of which parties had opportunities to cross-examine at the last hearing.
Overruled.
Mr. Bristner, you were retained by NOVPA or Mr. Bolus in some capacity to prepare the plans for this project. Is that right?
It's
Mr. Brewster, right?
Brinzer.
Brinzer, you're
I'm
still
sorry.
under
I
you're
am
s-
terribly sorry.
Okay.
you're still under oath from the last time.
It's okay. Could you repeat the question, please? Sorry.
Mr. Bolus hired you to, your firm to present the plans in this case, right?
Yes.
Okay. Were you was your firm responsible for the preparation of the plans that were submitted and considered by the board in 2023?
Yes.
Okay. I'm going to ask just a couple questions of you. I'm going to then, because Mr. Bolus deferred to you on a couple of these matters, I want to make sure that the record is clear. But Mr. Cluck is going to ask you some questions when I'm finished that we had prepared for him to ask you tonight. First question for you, Mr. Brinzer, right? I got it right this time. I'll try and keep that consistently. You prepared applicant's exhibit 21, right?
Yes.
And counsel for the applicant indicated, the only change is the screening that appears on Kaplan Court.
Correct.
And that screening was added in order to comply with the requirement of the ordinance that states that any loading, off-street loading or unloading areas be screened from any public road, right?
Correct.
That hadn't been brought to your attention by anybody prior to the May 2024 hearing? Is that right?
I was advised by our attorney. I don't know when the actual comment was made to him by the zoning officer,
When did
but
you?
approximately that time frame, yes.
Okay. And when was this drawing prepared?
This was revised on Friday, this past Friday, with the additional landscaping.
Okay. Is there any other additional landscaping other than that which appears around Kaplan Court?
No, the change occurred by extending the landscaping from the proposed car parking along Route 94 down to Kaplan Court and around Kaplan Court. So we just extended it from what was shown on the prior plan.
Okay. So there is a 50-foot setback that applies to the commercial district, correct?
Correct.
And for the building, for the proposed Lot 1 and Building 1, that is, the front yard setback would apply to Route 94 and to Route 30 where it touches both, correct?
Yes.
Okay, do you agree with me that the ordinance defines the setback as an area parallel to the public right-of-way line in which no structure would be erected and no building would be built? I'm paraphrasing, but generally that is the
setback,
requirement.
Yes.
Okay. And are you familiar with the definition of structure under the ordinance?
Yes.
Okay, it's any man-made object having an ascertainable shape or that whether or not it's affixed to the land, correct?
Yeah.
And it doesn't include or exclude parking, is that right?
Does not.
Okay. On the Lot 1, correct me if I'm wrong, but it appears that your parking facility exists within the 50-foot setback from Route 94.
Let me rephrase my prior answer. I would have to double check the definition of the setback. And now that you're, I don't know that the parking applies to that. I would have to double check that.
Okay.
And typically, parking is not included in a typical front yard setback. It is permitted within the setback a lot of times. So I'd have to look back at the definition to verify if this is permitted.
Okay.
And if it is not, we could shift the parking back behind the setback. So that
Okay.
could be obtained in that case.
Now, and on the printed version of this plan, it's obviously a little harder to see, but if one were to zoom in or look at the a blown-up version, there's not a lot of space between the truck parking area and the employee parking area.
Correct.
Okay, and you'd agree with me that there isn't even necessarily 20 feet.
Correct.
Is that right? Okay. And there are no sidewalks or other features shown on the plan that would allow employees to have access from that parking area to the building, correct?
Correct.
Okay. So, and there's no circulation arrows that are shown within the truck parking area for proposed warehouse 1. Is that right?
That would be correct.
Okay. Do you know whether or not the Yake property is a residentially used property?
Sorry, which property is that? This plan I have is very small.
Top left-hand corner, right where the north arrow is on page 1 of 3. And this is, again, Exhibit 21.
I do not know if that's residential or not.
Okay. You do not show a 200-foot residential, and the ordinance provides for a residential setback as opposed to a buffer, correct?
Correct.
Okay, and that's subsection, that's 150-98 DD, I believe it's 4 if I'm not mistaken. Is that your recollection, sir?
It is.
Okay.
And I would say that even though the setback line is not shown, we provide more than 200 feet from those property lines to the structure, to the
Okay.
building. So we
But-
still comply.
Okay. But, and you refer consistently on the plan to that being a buffer as opposed to a setback. Is that right?
We do. We call it a buffer, but it is, yes, buffer setback. We're still
Okay.
complying with that line.
And those,
Those dimensions.
and in your experience as a registered landscape architect, that those terms are not exactly the same. They are not fully
They-
interchangeable.
Correct, they are not, but we are treating it by not encroaching on it. We are treating it like a setback, but yes, the terminology should be referenced as a setback.
Okay. And you were here throughout Mr. Bolus's testimony tonight,
Yes,
and you would agree that there is nowhere on applicant's exhibit 21, is there a reserved parcel of 10 acres, a reserved parcel of 2 acres, or a even 10-acre configured, for the Myers Trust as to 10 acres, the Shoal Estate 2 acres, or the Lawrence property a retained up to 10 acres, correct?
for the Myers property, we do not depict the 10 acres. However, there is plenty of land fronting on Route 30 that would not impact the development, since it's a
Okay.
50-acre tract, 51 acres. On Lot 2, is it Shoal, did you say?
That's right. the Shoal Estate.
We do not depict the 2 acres on there at this time. And on the Lawrence tract, we do depict proposed Lot 5, which is 2.56 acres, fronting on Route 30, on
But-
sheet 3.
But not a 10-acre, not an up to 10-acre parcel that would include the creekside area that the buyer didn't want to really buy anyway.
I would say the 2.56 acres is part of up to 10 acres.
Okay,
So
but,
it goes approximately to the creek line.
okay. But the property that you're buying from, he is buying, or the NOBPA, and just be clear, is buying from the Lawrences extends in an easterly direction along the creek farther, correct?
There's 2 parcels, there's 2 Lawrence parcels.
Right.
Yes.
And the Lawrence parcel currently extends all the way to the Grimm property to the east?
Correct.
Okay.
Yeah.
So, the creek runs in that area closest to Route 30 in sort of a corridor in a diagonal north and east direction. Is that
Correct.
right? Okay.
Yeah, so additional land could be reserved in that direction, northeastern land, to
Okay.
add additional acreage without affecting development if we needed
Now,
to.
on page number 1 of 3 of that site plan, you do provide zoning data that includes things like maximum lot coverage and percentage permitted. Is that right?
Correct.
And setbacks, et cetera, and again, for a warehouse specifically, what the lot coverage can be on the total site, correct?
Correct.
And you have, in this instance, aggregated, you've combined all of the lots to come up with the numbers that you have there. They're not separated out by specific proposed lot in terms of the total lot coverage. Is that correct?
Correct.
So, for instance, with regard to Lot 1, if you took away 20% of the purchased property, or approximately 20%, by going from 51 to 41 acres, that does affect lot coverage for that individual lot,
It would, but I don't believe it would exceed the allowable 60%.
okay? Do you have, if you can tell us, I know it may not be decided yet, and if that's the case, just tell us, do you know whether or not the intention is for the various lots to be able to, in the future, be sold separately?
That's beyond my knowledge of the,
Okay. Were they designed and laid out to be standalone parcels?
these proposed lots?
Yes.
Yes.
So that each one would meet its own setback requirements, each one would meet its own lot coverage
Correct.
requirements? Okay.
Yes.
All right. Now, are you familiar with the location of the residential property that exists on the Shoal Estate? The
I-
residential structure? Excuse me.
Yeah, it's an unoccupied structure right across from Stanley Drive.
Okay. So it is in fact across from Stanley Drive?
I've just come to that knowledge this evening. Yes.
Okay.
That's the one you're referring to, yes.
Would you agree with me that one could not retain that structure and in its current location if that driveway were to be approved and constructed as shown on this site plan?
I would agree with that.
Okay. I am assuming you have not been privy to any communication about the possibility of relocating that structure to a different area of the property, correct?
I'm not.
Okay. And in addition to where that driveway is, there is also a right turn, a deceleration lane off of Route 30 going westbound that would implicate that structure as well. Is that right?
Correct.
Okay. You note on the plan that that lot, you'll have to forgive me, I may be thinking of a different iteration of this, but on proposed lot 5, on page 1 of 3, under site data, it refers to an existing proposed lot 5, with a tract area of 2.56 acres. And it says existing commercial to remain. Is that the Lawrence property?
So, I believe prior to one of the
If
previous, I can clarify that.
I
If
can
you want to.
object real
Okay.
quickly here. On Exhibit 21, which we're looking at, proposed Lot 5 is existing residential to remain, is what that says.
I'm sorry? I'm looking at site data on page 1 of 3, the last line above gross area that says,
Okay. Yeah, I'm looking at the zoning data with the proposed use
I-
of proposed Lot 5. I think Eric can probably explain.
I can
this.
clarify
Yeah.
that.
Okay, great, thanks.
So if you recall, prior to one of the previous hearings on this earlier, we submitted a revised plan and indicated in the zoning data, we changed proposed lot 5 to say existing residential. What I didn't realize is under site data, it said commercial. So we changed it in one location, didn't realize we had a duplicate terminology, but that is a residential property. That was
all
a
right.
mistake, yes.
So in other words, it was a typo.
It was a typo.
Okay. Thank you for the clarification. So on this plan, this is the 4th iteration since the resubmission in November of 2023, is that right?
Possibly.
Okay. There was a November, a December, March,
That would make 4, yes.
and this one.
I'll say yes, I'll agree.
Okay. In the corner where it says date 3/27/24, it says per amended special exception criteria revision. Can you tell us what that refers to?
Sure. On page 1, you see at the top, you see the parking summary in the upper right-hand corner.
Indeed.
To the left of that is the special exception requirements. When we submitted the initial application, we copied the special exception criteria that was the old section HH was on the plan. We replaced it with section DD. That's what that revision was prior to that, after we resubmitted the plan prior to the first hearing. I don't know the date when we resubmitted that. I guess it's on here.
That was the 3/27
Yes, correct.
immediately prior to 3/28
Correct.
hearing. Okay.
Yep. That's when we realized that terminology wasn't updated with the new zoning data.
Okay. Can you point to in the materials that you have prepared or have submitted on behalf of the applicant, and I'll ask this clarifying question first. Has there been anything submitted as to the operation of this site, the proposed layout, or anything that meets the ordinance criteria that has not been prepared by Ritu? Have you used had any other outside consultant been used by the applicant?
No,
Okay.
other than traffic counts, obviously. There's a
Okay.
consultant for that, but not all of these documents were prepared by Ritu.
And you're saying that the actual manual counts were
Correct.
done by a subcontractor?
Correct.
Working for Ritu, though?
Correct.
Okay. So is there a detailed truck parking and staging plan that exists?
There is not, and if you refer to section 15098DD, under number 16, it says in addition to the other requirements located on here that a truck parking and staging plan must accompany the site at all times. So one would be provided during the approval process and would be on site, but it has not been prepared at this time. We do show truck parking, we show the truck bays on the plan, but we do not have a specific staging plan at this time.
Okay. In the course of your work as a registered landscape architect and appearing on behalf of applicants, you've done this in other cases before, correct?
Correct.
And in doing so, is it part of your job responsibilities to familiarize yourself with the specifics of an ordinance?
Yes.
And are you required, while not making legal conclusions as to the impacts of an ordinance, you'd certainly have to have training on being able to read and apply them to prepare these plans?
Correct.
Okay. And the preparation that you do is so that the board can rely on what you've provided in order to render a decision as to compliance?
That's correct.
Okay. Do you agree with me that the 150.98 parentheses DD, subsection 16 and subsection 2, 16E2, says that the following conditions shall be satisfied to justify the grant of special exception. The applicant shall include a detailed truck parking and staging plan for the development, correct?
That's not what it says.
Did I not read it verbatim?
What does it say, David?
I was looking at a different section. My apologies. Go ahead. Yep.
Overruled.
Go over. Yep.
That is what it says.
Okay. And to be clear, your testimony was that that was not prepared to date, correct?
We show truck parking on the plan, but we do not have a specific staging plan prepared.
Okay.
I would,
So-
I would suggest that truck parking area could be used as a staging area, but we don't have that specifically identified as that.
Okay. And the area on the backside of proposed warehouse, the 621,000 square foot warehouse, there's no internal circulation plan depicted for traffic in that area, correct?
The access ways are shown, but there's no specific circulation plan.
Okay. we heard there have been some questions presented relative to section 150.98.DD9 that concerns the vehicle service and repair activities to be conducted within a completely enclosed building, or completely within an enclosed building. Would you agree with me that the plan as submitted does not depict any area for vehicle service or repair inside a building?
That's correct, because they would have to be towed off-site to be repaired in order to comply with the ordinance.
Or there would have to be an area within the building provided for it, correct?
Correct. There could be a bay provided within the building on the south side where the truck parking comes up. That would allow for that, but that would be up to the developer of the building itself, the
But-
future owner,
but
or they
that-
would take them off-site.
As it is now, there is nothing depicted.
No, they would have to be towed off-site.
Is there any area designated on the plan for overnight parking or for an area for a driver to take a mandatory rest break if they are out of hours?
No, we have trailer parking on the site, but we do not have that.
In fact, there is no parking area that is dedicated for tractors or power units, as they may be referred to, correct?
Not at this time.
Do you know whether or not this plan would require the use of yard jockeys?
I do not know how that would be operated.
Okay, so that goes to the use itself, correct?
Could you repeat that, please?
I said that goes to the use itself, whether or not you would need to utilize yard jockeys.
Correct.
And in some warehouse uses, you use them, and some you don't. Is that fair?
Fair, yes.
Is that a person or a thing?
That is a thing. That is often a natural gas powered small tractor, a smaller tractor that is used for merely manipulating empty trailers from a parking area to a loading dock. And they can go out on the road, but they aren't meant for longer trips.
Is that the applicant's understanding of the term yard jockey?
Yes.
Or at least it's the engineers.
Yes.
All right. If I can have just a brief moment. I have no other questions. Mr. Clark, I've been prepared to ask you a couple of questions. Thank you for your responses.
Good evening, Mr. Brinzer. Have any of these plans been reviewed by the Planning Commission?
That would be a question for the township. I don't recall. I think initially we presented a sketch plan early on in the process. That was prior to submitting the special exception.
Be more specific. The resubmission occurred in November, correct?
Correct. No. Before we submitted the special exception, we did, I personally presented a sketch plan of the site to the Township Planning Commission. It was an informal sketch plan discussion, but I don't know if these plans have gone before the township. I don't believe we've presented them to the Planning Commission, so I don't know if the Planning Commission reviewed them or not.
Your informal presentation, was that the plan that was denied by the zoning hearing board?
Yeah, that's correct. That was the prior plan. So this plan was not.
Okay.
Yeah.
So the prior plan that was denied by the zoning hearing board, what are the differences between that sketch plan and the sketch plan submitted on November the 6th, 2023 as part of this application?
May I ask what the relevance is?
No.
Okay.
I believe this was already testified to in depth at the first hearing. Had they been present at the first hearing, they could have asked questions about that or listened to it at that time.
I've read the transcript, and there is no discussion about the differences other than the number of variances sought. I want to know what the differences are on the site design.
I can do that.
Thank you.
I can give you a brief overview. I don't know if I can recall every exact change.
Just give me the big details.
Sure. So
Well, hold on a second. Are you withdrawing your objection
Yes.
since your engineer's ready to testify?
Yeah.
Thank you.
So I'm going to give you a brief overview of that, if I may, because I don't have that plan in front of me. But there were various variances that we requested. We revised the plan to avoid encroachments into wetlands where it was not permitted. We shifted the loading spaces. We made it a single loaded building, the larger building, so that those spaces would be the furthest away from the closest residential. We shifted building 1 closer to the road so that it would touch the setback. We shifted the driveway along 94 going into building 2. We shifted it down so that the headlights would not be into the adjoining opposite residential property. Those were the major changes, I believe, that we made.
Okay.
There may have been others.
You proposed 2 warehouses in both prior plan and current plan.
Correct.
Why did the square footage change in both of them?
It was just with the revised design, that's what we were able to achieve and meet the ordinance the best that we could.
But the use as 2 warehouses did not change, correct?
Correct. That's correct.
When did the use of lot number 4 change from 6,000 square feet to 8,000 square feet fast food restaurant?
I don't recall at what point we made that change, but we were essentially depicting 2 commercial uses that fit on those lots yet to be determined. So I don't know that, I don't recall when those uses changed. And are you referring to my site plan for the use, or are you referring to something depicted in the traffic study?
Does your site plan reference an 8,000 square foot use on lot 4?
No, we showed as 6.
That hasn't been revised with Exhibit 21?
I'm looking at, bear with me.
Mm-hmm.
So I'm looking at the parking summary commercial uses, lot 4, 6,000 square feet.
So what is it? Who's accurate, 6,000 or 8,000?
Where are you getting 8,000? Where do you see 8,000 on the plan? I don't know, I'm asking.
Your traffic study is based on an 8,000 square foot use on lot 4. Are you telling me the traffic study is not accurate?
Object that probably the best witness to ask about the traffic study would be Mr. Schick, who will be here tomorrow evening.
Overruled. You can answer the best you can on that.
So I'm a landscape architect, I'm not a traffic engineer, so I'll state that. So this is my opinion. The site plan currently shows a 6,000 square foot building on that lot. If the traffic study depicted an 8,000 square foot building, that would only be a worst case scenario. And it would make it worse, it would not make it better as far as less traffic. So I don't think that would have an impact. I think that's showing a more worst case scenario, in my opinion.
The criteria for special exception appears to require a site plan showing building dimension. What site plan should the board rely upon for determining building dimensions?
So the special exception we're requesting is for the warehouse use, not for the commercial use. But the site plan that I had in Exhibit 21 would be the accurate building dimensions.
The November 6th resubmitted application was 78 pages. It included a narrative. Has the narrative been prepared by your firm?
May I see the exhibit?
I think it's Township Exhibit number 1.
Are you looking at the application?
Yeah. And
Yeah, cover letter, check, narrative, and then A through G.
yeah, that's
No, I did not.
Do you know who prepared the narrative?
Mr. Sheedy.
Has the narrative been revised in any way since it was submitted in November?
You'd have to ask Mr. Sheedy.
The answer is no. The narrative has not been revised. To the extent that any changes in the narrative happen, the narrative is not testimony or evidence as much as it is to provide background to the board. As part of the application, the testimony and evidence is provided at the hearing before the zoning hearing board. I think you should know that.
I would move to exclude the narrative as evidence in this case unless Mr. Schuette's going to testify.
Give me your argument.
Well, Mr. Schuette just testified it's not evidence. It's merely to explain some things. They have an obligation to prepare substantial evidence. If they're going to rely on statements in the narrative to demonstrate substantial evidence of compliance with the criteria, then they need to put on somebody to testify about it. If he's now testifying it's not evidence, then strike it from the record.
Do you have specific sections in the narrative you're concerned about?
I don't have specific sections of the narrative.
No, I'm asking
Okay,
him.
okay.
Do you have specific sections in the narrative that give cause for concern?
I was not prepared to cross-examine anybody on the content. I was merely asking if it's been updated. The answer is no, it hasn't been. He then volunteered that it's not evidence, so as a result, strike the whole thing.
What's your argument?
Well, I don't think it much matters. I mean, it is admitted as evidence as the township's document, as the application that has been submitted. Now, this board's obligation, this board's authority is to review the evidence and testimony that's presented based upon the plans, live testimony, sworn testimony. I mean, this is at best hearsay anyhow. So to the extent that the application is to be, to the extent that the narrative is to be taken as facts and to be relied upon this board solely as facts to support any of the criteria of the special exception, I don't mind if it's stricken.
I think we can leave it in and we'll give it its appropriate weight.
I just want to know for the record, apparently the narrative is the only documented or documentary evidence of their request for a variance.
Does it appear on the body of the application?
Where's the application on the November 6th resubmission?
Stamped November, received November 6th.
Okay, let me move on. Exhibit F as in Frank of the November resubmission is titled Sketch Plan.
Mr. Brandt, just to respond to your question, the application cover sheet incorporates the narrative. That's the only place
Yeah.
it details the request.
Okay, understood.
If I could respond to that real quickly, the variance was discussed at length and requested at the hearing and understood to be requested at the hearing in March. And I believe, again, the opportunity the opportunity was in March to make that point.
It was requested, it was discussed, there was testimony, that was the advertisement for the hearing referenced the variance. So it's part of the application.
To finish. Mr. Brinzer, Exhibit F as in Frank is titled Sketch Plan. It's dated October 28 of 2023. It's at page 68 through 71 of the resubmission. I then see Exhibit 6 in the applicant's exhibit book at page 79. That sketch plan is dated November 29 of 2023. Now, I also recognize there's a revision of March 27, and you've just testified the revision for March 27 was to change HH to DD. What change occurred from the October 28 version that's in the Township's exhibit booklet versus November 29 of 2023, which we don't have?
I believe that was also testified to at the last hearing.
Yeah, but somebody remind me.
I would need to see the documents.
So
Are
what do we,
those
what do we,
the two little things that were needed to be changed to make a correction, if I recall the testimony from March 28?
what are we comparing? We're comparing Exhibit F in the application packet to the binder presented at the first hearing?
No, the binder Exhibit 6 is March 27. I want to know about the November 29 version that we don't have. Now, it may have been testified to, and I recall the testimony from counsel was that there was two minor changes.
Didn't you guys bring a big version to the first hearing on foam board?
Just, do you have a copy of the booklet that has the exhibits with the plan itself? Could I borrow?
Yeah, that's Exhibit 6.
Hold on. I just need to see it.
Okay.
I recall you guys pointed out a difference between the foam board and what we had in the application, but I don't remember what
Correct.
the difference was.
Which one is this? That's this one. You said six
Right,
and
well,
F.
6 is March 27, and you said the only change is changing HH to DD.
Where's Exhibit F?
I'm trying to find Exhibit F for you here.
Sorry.
That's okay.
I don't know if I can have it.
We ain't going anywhere.
It's part of the
Oh, yeah, here
application
it is.
packet.
Yeah,
I see 1 through 12.
yeah,
But
here you go. Here it is. It's Exhibit F.
thank you.
Do you need to go off the record for a couple minutes to study all these versions of the plan?
Yeah, they're very small. I just need a minute to just
That's
see
fine.
what if I
Go
can
off the
recall what the
record.
change was.
We'll let the engineer take a look at the different versions of the plan, and then we'll come back on. What kind of picnic are you having? And old Christmas candy? Christmas lollipops? Nope, hitting sheets when we're done here. Two for one chili dogs. Big sheets is 2 for 1. 11 o'clock chili dog run? Come on, just like a college. You guys can jump in anytime. Don't let me steamroll you.
I'm as ready as I'm going to be.
All right, we're going to go back on the record. Give us the question again, sir? What was your question?
What were the changes that occurred from the October 28 version submitted as Township Exhibit 1 to the November 29 version that we do not have, except that we have Exhibit 6, which is revised March 27, and your testimony was the revisions for March 27 changed the ordinance revisions from HH to DD.
So from what I can tell on these small plans that I'm looking at,
Well, I thought we were bringing a larger version of Exhibit 6. If I recall the transcript, they were supposed to bring a larger size
Well-
so we could read Exhibit 6.
all I can see is, I'm talking about Exhibit F, is very small in this
Oh.
booklet. So
Oh, my apologies.
that's okay. From what I can tell, the site plan is virtually identical. We removed an emergency access road from behind Building 1. Other than that, they look fairly identical. So there was no other substantial change to the layout between the two.
The size of the warehouses didn't change?
As far as I can read on this plan, I believe they're the same. I just can't read it.
The applicant's exhibit booklet includes as exhibit number 5 what is called a rendered site plan dated March 28 of 2024. It's at page 78 of
Yes.
the 134-page booklet. Why wasn't a rendered site plan included with the November resubmission?
This was more of just a graphic representation to be used at the meeting. I don't have an answer for that.
Is there a December 29, 2023 version of the rendered special exception plan?
I don't recall. I don't believe so, but I don't recall.
Let me direct your attention to Exhibit 5.
Yes.
Does it indicate a proposed commercial use of 8,000 square feet?
It does.
Who prepared the rendered site plan?
Ratu.
So I guess I don't need to question the traffic expert tomorrow about where he got it from?
Sure. Again, it's, I don't know that it is relevant to the application, so.
Was the rendered special exception plan dated December 29 provided to the traffic expert?
I don't think we've ever established that there's a rendered special exception plan dated in December.
Well, we'll find out tomorrow night when we look at page 85 of the 934-page traffic study, which is the December 29, 2023 rendered special exception plan. So my question is if this witness, Mr. Brinzer, knows the differences between the 1229 version and the one that has been marked as Exhibit 5 for the board.
Not without relooking at them, I don't recall the difference.
Well, but was it provided to the traffic expert by Ritu?
He works for Ratu, so if he has it in his report, I would say it was provided, but I don't recall.
Does the sketch plan, which I guess you're referring to as a site plan, does it depict the grading of the property?
Existing topography is based on LiDAR. We do not depict proposed grading.
Are there any steep slopes greater than 15% on the site plan?
I believe there are. I don't have those at my fingertips as to where they might be.
Are they identified on the site plan?
Not on sheets 1 through 3 of 3.
Did you review the provisions of the Natural Resources Protection Overlay Zone?
At some point we did, yes, through the development of the plan.
Okay, and where on the site plan do you depict the delineation of the natural resource protection overlays?
Well, we're depicting the streams, wetlands, required buffers, and riparian buffers that are associated with those protection areas, associated with the streams and wetlands.
But there are steep slopes greater than 15%.
I would have to confirm where they're at. I believe so along the stream, but I would have to confirm that.
Is any portion of the proposed development located within a designated floodplain area?
Only where the roads cross.
And your intention is to get a DSE permit for that?
DEP permit, yes.
That's all I have. I think Mr. Wolf has one more.
I did have one other brief area that I had to ask you about, sir. On Exhibit 21, page 1 of 3, or 3 of 3, either one, it depicts 37 trailer parking spaces, a depth of, I believe they are 60 feet. Is that right?
Correct.
And you have a drive aisle that is 65 feet. Is that right?
Correct.
And is there, in your prior iteration of the plan, the 2023 version that went before the board, there were dock doors across almost the entire front of the building, is that right?
On the plan that was denied, yes.
Okay. Is there any reason, from an engineering perspective, that the the 37 parking spaces could not be located next to the 53 that are adjacent to the building?
For circulation purposes and access to the road coming off of Route 30, that was the ideal location to keep them in that area. So there could have been many, obviously there's 10 different ways to design every project. So this is where we located them to come off of that access road to provide access that would still provide clean access on the main access coming off of Route 30 over to 94.
Okay. If you located all of those all of those spaces adjacent to the warehouse, is it possible to shift the footprint of the building closer to Route 30?
Potentially.
And the request for the variance is a request to exceed the requirement that the building be built at the setback line by, I believe it was 506 feet.
Roughly, yes.
Okay. And again, that would be 125 feet between the 60-foot, 60-foot depth for the spots and 65 feet for the drive aisle.
Correct.
Because the drive aisle could be thinner if it did not have to accommodate two-side parking.
Potentially.
Okay.
Yeah, the clarification I'll make there is that the commercial zone setback requires the building to be at the setback. Under the Section 150-98DD, it indicates that the building shall be at least 50 feet. I think that's where I saw that.
Okay.
At least 50 feet. So there's two different criteria there listing that setback. Just to
Understood.
point that out.
But it could be built closer to the setback line by any distance if a different design were used here. It isn't impossible to do. Is that fair?
Potentially, yes.
Okay. No other questions.
Redirect.
Yeah, we'll go backwards on this. As to the design of the site, Mr. Brinzer, is this the most reasonable way to design this site, and in consideration of safety and all of the other special exception criteria, in particular the traffic pattern within the lot?
Yes, I believe so.
And even though it would be, I guess, physically feasible to place those 37 parking spaces on the left-hand side of the front of the building, it's your professional opinion that it would not. Is it your professional opinion that it is not that this is the best design and most reasonable design for this project?
I believe so.
With respect to Lot 1, would you be prepared to, if requested by this board, or to supplement the record to would you be able to calculate the lot coverage and building coverage calculations for all 5 proposed lots?
Yes.
There was a question that was asked.
Somebody asked about differentiating between the lots, or were all the numbers just an aggregate? So I think that is
Yeah.
not beyond the scope.
Yeah. Would you be able to calculate that and provide that information to the board?
Yes.
Okay. In addition, would you be able to calculate if there was if there were portions of the lots reserved by the sellers as set forth in the agreements at the acreages that are provided? Would you be able to provide calculations for the board that the lots would still meet the dimensional standards required by the ordinance?
Yes.
Okay. In your review of the ordinance and preparation of the plan, did you identify any issues with steep slopes?
Not in the areas we're proposing to develop.
And in fact, is there any request for a variance as to any steep slopes or any other environmental criteria of the zoning ordinance?
No.
In fact, wasn't the zoning ordinance, wasn't the application that was denied earlier in 2023, one of the changes made was to avoid a variance as to one of the environmental criteria, correct?
Correct.
Is it your professional opinion that a difference between the 6,000 square foot commercial building, 8,000 commercial square foot building, if it is in fact a 6,000 commercial square foot building, would not substantially change the any criteria that we're dealing with tonight as the site plan?
Correct. I don't believe it would.
And in fact, as just to reiterate, is any special exception required to use proposed lots 3 and lots 4 as commercial buildings?
No, it's not.
I have nothing further. again, I think Mr. Schick can testify to that. I just asked him a question as to site plan.
Did say special.
Okay. And I have no objection. Go ahead. and
So, as I stated when you asked me the question earlier, I don't believe including an 8,000 square foot building in the traffic study versus a 6,000 square foot building shown on our site plan would have a detrimental effect. It's looking at worst case scenario.
I understand, but your counsel asked you specifically about special exception criteria. Apparently, he was wrong, wasn't he?
I'd have to hear the question again. I apologize. I'd have to.
I didn't think I was testifying, but
Guys, behave. Nathan, I have a couple questions. So if the Schaff estate, oh my gosh, I can't read. Scholl estate elects to keep the residential property as they're presumably entitled to under the contract, what does that do to your plan?
The access could not align with Stanley Drive, so the building would have to be relocated if they wanted to retain it.
David, do you need a minute off the record? Yeah. Okay. Okay. Start at 6 tomorrow. Who knows? Who knows? No later than. Oh, introduce it. Introduce it. See you tomorrow. You good?
yeah, as to your
Well, let's go back on the record.
sure.
Okay.
Yeah. Mr. Bransky, as to your question, I think we will deal with that when we have our opportunity for rebuttal testimony as to the location, of the reserved property.
My question to the engineer was if the Shoals elect to keep the residential property as the contract provides, what would that do to your plan? And you said it would impact the access route,
The access point.
the access point. Okay. With the application has a sketch plan in it. The exhibit book has a sketch plan in it. I think we were handed large-scale versions of the sketch plan at the end of the last hearing, or at the one we continued. There was a sketch plan on foam board. Exhibit 21 is a sketch plan. Which one of these would you like this board to consider as the official site plan to meet section 13 of the ordinance? Which is the
Exhibit
the real
21.
version? So we can disregard everything else and consider Exhibit 21 as the official site plan submittal to meet the requirements of section 13 of the ordinance.
Yes.
Members of the board, do you have any questions for the engineer? Township, any questions? Back to you, Mr. Wolf.
Helps to turn that thing on too.
It does.
Even if I lean at it and it's off, it doesn't work. The concern that I have, Attorney Schutte just mentioned something about dealing in rebuttal. I think I'm going to make the request that before the applicant closes its case in chief, that we have the documentary evidence that shows that it actually maintains an equitable interest. Because if there isn't an equitable interest, there's no objector's case really to put on if they don't have standing to move forward.
And what specifically are you concerned? What piece of documentary evidence that they would provide would satisfy that issue for you?
That they have valid agreements of sale that exist beyond the dates that are in the agreements now, and that they have some sort of documentary evidence that suggests that the agreement, that the Myers Trust likewise considers that agreement to be continuing and valid.
So if they came tomorrow with fully executed addendum to each of those contracts that puts the date of settlement out past tomorrow's hearing, does that satisfy you?
I think all three of them have that.
Well, I'm asking you.
Yeah, all three of them have
Well,
that.
what I heard was they exist, but they may exist at the home office.
the all of the addendums in this that have been submitted as exhibits have the date of closing well beyond today's date. All three of them do.
Okay.
If I'm not trying to argue with you, Mr. Schutte, I believe that both the Lawrence and the Shoal Estate exhibits expire as of March 2024, and that the Myers Trust was extended with an option conditioned on the payment of $50,000 to 2025, but it otherwise, I believe it
Let me
expired
let me
2024.
direct you to the addendum endorsement to agreement of sale for Lawrence. Says, quote, closing on the property to take place on or before March 30, 2025.
What exhibit is up?
It is in Exhibit 3. Let me put you to the same type of addendum attached to the Shaw agreement, and that last sentence of that also reads, closing on the property to take place on or before March 30, 2025. As to the Myers agreement, says that settlements take place on or before March 16, 2024, with the option to extend until March 16, 2025 for the additional $5,000 deposit, which shall be applied to the purchase price. Again, although I was testified that the $50,000 deposit was not paid, there's testimony under oath that there's been no termination of this agreement due to failure to pay the additional $50,000 deposit. So I don't see how there's any question of equitable ownership based upon the documents that have been testified to.
Mr. Wolf, what's your position on that?
I think that I'm trying to bring up the page that Mr. Schutte was referring to, and I apologize.
For which contract?
On the Shoal and the
The last page of Exhibit 3 for Shaw, and I don't know, I don't have my page numbered, but
Well, let's
is
stop there. So that exhibit says that settlements extended.
on or before March 30, 2025.
Correct.
I said I don't have the page numbers.
Yeah, our exhibit books aren't numbered, so
Yeah.
you've been referencing page
yeah,
numbers.
we were
this whole hearing.
referencing the pages in the PDF version.
Oh, okay.
And then go
And-
back.
and
go-
Mr. Schutte, would you kindly at least give me the date of that extension agreement? You said it was
March 23, the date of the extension was signed September 15, 2023.
Okay, give me just one moment and I'll catch up to you. I apologize.
Does he have a different book?
No.
I don't have the book.
Oh, yeah.
All I have is the electronic version.
So everything's on your laptop.
It is.
Okay.
Well, and actually, I don't know that there was well, the document, which speaks for itself, says that the due diligence would be extended until March 30, 2024, and at that time, if all due diligence is satisfactory and all township approvals are approved, a $50,000 deposit will be made into the closing agent's escrow account. And you'll please forgive me, was there testimony that that payment was made?
Again, all you're asking for is proof that we have equitable ownership.
Well, there
We
are-
have purchase agreements that have not been terminated and purchase agreements that say that closing on the property to take place on or before March 30, 2025. I don't know what more we can provide.
How about evidence that the condition was met? You don't have to have a written termination notice if a condition isn't met. It's a condition precedent. to the
It says at
extension.
that time, if due diligence is satisfactory and the township approvals are
Which
made,
we're-
then
which we're not given.
So we're not there yet. So no $50,000 deposit is due.
But that means that the due diligence period isn't extended. This is what
Does
lawyers
it
fight
matter?
about all the
Does it
time.
matter if the due diligence period is extended? Your question is whether the property is under agreement.
When time is of the essence, if there's no extension of the agreement in writing, and the
But the
conditions
property is
haven't-
under agreement.
Yeah, I think with respect to Shoal, that this is still a valid agreement. Let's go to the next one.
Lawrence?
Same language in Lawrence.
Give me a page number.
Uh,
Or not a page number. I don't have page numbers. Give
It's
me
it's in Exhibit 3. Before the beginning of the first Shaw contract.
All right, hold on. Go for it. Yeah. Yeah, ask away. Pull it up close to your nose.
So you guys are arguing about these contracts, right? And if my memory serves me right, Mr. Mullis basically said there was an additional contract that was extended
Right.
that he showed. He said he had it. He just didn't. He needed to go back and check it, right?
That's exactly right, sir.
So why are we arguing about this? Why don't we just have Mr. Mullis basically go back to his home office and get those documents and bring them tomorrow night?
That's what I asked for.
I have no problem. I have no problem with that either. But the documents as they currently sit show equitable ownership. Anyhow, I think the amendments, if anything, extend diligence. Correct.
So Lawrence, the amendment endorsement to the agreement of sale, electronically signed and dated September 5th, it looks like.
Signed only by Mr. Lawrence, but that's correct.
Yeah, Luann did not sign it. Says that due
What?
diligence is extended to March 30th, 2024, same language. And at the time, if all due diligence and township approvals are satisfactory, a $50,000 deposit will be made into escrow, closing to take place on or before March 30th, 2025. I think that contract's still alive. What's the next one?
Tend to agree. And then the last one is, there's a document titled Change in Terms Addendum to Agreement of Sale. And this is immediately before the first page of the March 2023 Lawrence Agreement in Exhibit 3. And that one reads that settlement to occur on or before March 16, 2024, with the option to extend until March 16, 2025 for an additional $50,000 deposit, which shall be applied to the purchase price.
Hold on, I don't have that one in front of me yet. Hold on. Is this the change in terms addendum?
Yes, yeah,
Signed
page 2 of the change in terms addendum.
May 25th, 2023.
Yeah, 25th and 24th, correct.
And I will note, Mr. Baranski, that this, the dates that Mr. Bolus was asked about for the formation of NOBPA LLC, this is signed 1 month prior to the formation of that entity. And we have not received any agreement that has been endorsed by the Myers Trust after the formation of that entity. And therefore, I question whether or not this is in fact a valid and enforceable agreement.
All right, well, I'll come back to that point. So this one is different. It says the option, can you hear me? The option to extend until March 16th, 2025 for, and, it should be an additional $50,000 deposit. So that one requires the purchase of the extension, right? Which is a
Correct.
little different than the other one.
I would say yes and no. I'd say that it's still under agreement that in order for the agreement to be terminated, even if settlement did not happen on time, for the agreement to be terminated, there needs to be a notice of default and termination by the seller, and been testimony that has not occurred.
And respectfully, it would be my position that on the terms of the agreement, that it is, pardon me, that it is self-satisfying that if the option isn't purchased with the additional payment as was testified to, that the option expired. That the contract expired by its own terms. It doesn't require a notice of default because it is beyond the extension period.
I disagree. I don't think it's this board's duty to interpret contracts.
Well, let me read the default section for the buyer. The relevant part, I think, says, buyer otherwise defaults under this agreement, and and that default, I would say, would be the failure to tender the 50 grand for the extension,
Or complete settlement.
or complete settlement because you didn't buy the extension. And such default remains uncured for 60 days following receipt from seller of written notice of said default. Then it goes to the remedy. Has there been a written notice of default?
I think the testimony's been no.
So is it the argument of the applicant until such time as a written notice of default is received, the contract is valid?
Yes.
And what's your take on that after
I-
reading?
that because the site investigation period, which was defined, it says if under that circumstance they failed to complete settlement, or any time otherwise defaults under this agreement, just rereading.
It says, or buyer otherwise defaults. That's the general term.
However, it is also a time is of the essence settlement, time is of the essence agreement that requires the.
Requires, which would require a cure within,
Excuse me, sir.
require a cure within 60 days after notice.
But this is why cases get litigated, and the point is that you don't move forward on a land use application if there's a question as to the validity of the contract. And if you've got a posted for sale sign by a new broker, and you've got communications from that broker saying that the seller is believing it to be not under contract, then we have a serious question as to whether or not the applicant has the authority to continue to maintain its application.
Can that concern that Mr. Wolf has be remedied with something by tomorrow?
I don't think it. One, it doesn't need to be to have colorable title at all. I mean, we have an agreement of sale that has not been terminated, and there's been no testimony that it has been terminated.
But it was endorsed by an entity that didn't exist.
That makes it voidable by the seller, if
that-
anything.
Can that issue, that's a different issue.
No.
Can that issue be remedied?
No, I mean that issue can be remedied that issue could be remedied also. I don't know if it can be remedied in 24 hours, but that issue could also be remedied. But again, that does not change. That's not a concern of this board. That would be a concern of the seller if the seller wanted to void the contract. It just makes it voidable. Doesn't make the contract void.
It most certainly does. You're
No,
being
it
asked
doesn't.
to
No, it
rely on
doesn't.
the validity of an entity that didn't have the authority to contract, and they're trying to say they have a valid contract. And you have a seller's agent saying it's not under contract.
Again, that's not in the record.
We have to disregard the Bodie thing because we determined that that was hearsay. So let's not bring that up again. So, Mr. Wolf, your position is, with respect to the formation date, that the state records demonstrate that the applicant's LLC was formed when?
June 27th, 2023 in Pennsylvania, and June 23rd, 2023 in Delaware.
Which is after the date of the
Post
contract.
dates that agreement by almost a month.
I'm going to take that under advisement for tomorrow. But I understand the legal arguments on both sides.
And if I understand, the board has the authority to issue subpoenas. We could certainly subpoena Mr. Bodie to come in and testify as to what the status is of the agreement.
He's not an expert on law.
Well,
No.
he can certainly testify as a fact witness as to whether or not the sellers are maintaining that it's under contract.
Bring him in. I'm not going to subpoena him, but if he'll come in, we'll ask him that question.
All right?
I'll reserve the legal ruling on that concern over the Myers Trust contract specific to the LLC formation date. I think outside of that issue that there's a valid contract still because there has been there's testimony that there has been no default notice, which my reading of the default clause would be required before you could say the contract was terminated. But I do have a concern about the formation dates. So I'm going to rule on that tomorrow. Okay.
And I assume if the applicant has something else to suggest that his entity was filed other than what those websites suggest, then
Then they should bring it.
indeed. We had talked about having a brief opportunity for me to talk to my clients to see who would be prepared to testify. And
How much
more-
time? Do you need 10 minutes?
Yeah, if I can have 10, and then with whatever the balance of time for tonight, if you want to open it to public comment, then we would certainly have no objection, subject to our being able to resume our case. And I don't know if the township had any other
We don't
issues
have any-
tonight to address.
There's no other witnesses tonight. Okay, we'll take a 10-minute recess. Tangled web we're weaving here, sir.
Hey, Jim.
I'm more concerned about the formation date of the,
Yeah.
if the entity doesn't exist and it's out there signing contracts. But yeah, they should bring any addendums they have tomorrow. I'm gonna go back on the record, I'm gonna say, if you want us to consider addendums, bring them to. No, it's not scrambled hard enough. You can get anything from the office with a scanner and an email address. It's holding together. No, we're good. Don't curse us, man.
So you want the 2 acre thing?
Yes. From the front, I was 10 till I was 18. I don't, because I have I love the great indoors. My sister lives in New York.
Love every minute of it. This is good. I'm listening, not sleeping. Yeah. They're doing all right. I thought Mr. Wolf was going to go off more than he did, so he has a habit for running meetings long. Let's see. Hopefully he's not going to help with every one of his clients testing. It's coming. I'm sure they're all for it. Yep. We had a bigger crowd than last time. I think the interest is waning a little bit. Oh, because we had to continue it? Yeah, somebody ripped my antenna off my car. Yeah, I guess I just, I don't know how they knew it was mine. Yeah, I don't know. If I came out, it was. It happens. I'm used to it. Yeah, stuff like that happens. That's why I don't drive the good car. It's like if you watch the movie Roadhouse, where he would, did you ever see it? Patrick Swayze, he was a bouncer. And he, not the new one, the old one. And he knew that if he drove his nice Mercedes to the bars that he was settling down, that it would get trashed. So every time we would go to a bar and straighten it out, he would buy a junker off the junk lot and drive it because the windows would get broken, the tires would get slashed. So I'm like, that's what I'm doing then. Yeah. Right. You ready, David? All right, guys, let's wrap it up. Take your seats. Mr. Wolf. We usually swear in the citizens, right? Yeah, I've always done that. Nate's like, I've never seen that in 100 years. Huh? Yeah, I've always sworn in. Yeah, I always do that. Sorry. Mr. Wolf.
Yes.
Mr. Wolf, are you ready to proceed? Do you have witnesses?
I have a couple of my clients who are ready to go tonight.
Okay. Again, we're cutting off at 10:30.
I'm probably going to have a half an hour of my clients tonight, and then we can open the public hearing.
Okay.
All right.
Yes, we got to swear everybody in, Nate.
All right. Do you want to do it as we go, or do you want anybody who's going to testify tonight to do it now? Your call.
Let's do one at a time.
I do.
So can you state your name and spell your last name?
My name is Jeff Seibert, Seibert.
And what's your address, sir?
315 Forest Drive, New Oxford, PA.
And where is 315 Forest Drive relative to the property that the applicant seeks to develop?
I'm an adjacent property holder.
Nate, you need a microphone. There's 3 here. Take one off the table.
Right?
So start with where is your property relative to the blah, blah, blah.
Where is your property relevant to the site that the applicant seeks to develop?
My wife and I's property is located to the north of the Lawrence property.
So if we are looking at Exhibit A21, applicant's Exhibit 21, there is, directly to the north, there is a designation for the agricultural preservation zone.
That is my property.
And what I was going to ask you is in the very small print, there is a reference to Reading rental properties. Is that an accurate reference?
That is not.
Okay. What should it say?
It should say property owned by Jeff and Deb Seibert.
Okay. And there is an indication of a boundary line for commercial and agricultural preservation north of the applicant's property that is where commercial is above it on that drawing. Are both pieces part of your property?
I actually we own property which would be to the west of property owned by Jeff and Deb Seibert, and that would be in my wife and my name as well as my daughter and son-in-law. That would be partially commercially zoned, but the property owned by Jeff and Deb Seibert is residential.
Okay. And how many acres total property do you own?
In total, 200.
Okay. And are they all these, are both parcels that you just referenced the ones that you own with your, I believe you said daughter and son-in-law, or did I have it backwards?
My wife and I own roughly 150, and my daughter and son-in-law, along with my wife and I, own 50.
Okay. And, but is the property owned with your daughter and son-in-law also adjacent to the tract that Mr. Bowles, or NOBPA, is seeking to develop? Okay. Is your property on Forest Drive, the 150 acres at least, is that subject to any sort of preservation easement?
It is. We entered into a conservation easement.
And who is that conservation easement with?
Adams County Conservation.
Okay, so that's the county that's the county's agricultural preservation easement program.
That's correct.
Okay. And
Land Conservancy, I guess, is the proper name.
gotcha. So, do you live on that property, correct?
We live on the 150-acre tract,
Okay.
yes.
And do you actively farm the rest of it?
We lease out the farm land to our neighbor, Todd Grimm.
Okay.
He has agricultural crops as well as pasture for his cattle.
Okay. And and Mr. Grimm is also one of the objectors in this case, correct?
Correct.
Okay. And Mr. Grimm owns adjacent property to you that is to the east of the Lawrence property.
That is
The
correct.
current Lawrence property that the applicant seeks to develop, correct?
Correct.
Okay. So between your two properties, you wrap around the vast majority of the north and eastern borders of what is proposed Lot 2.
That would be correct.
Okay. Now that we've oriented the board where you live and what your interests are, can you tell us why you're here and why you're in opposition?
Well, specifically, the variance request asks for the building to be moved back away from Route 30. And the more you move that building back from 30, you move it closer to my property. I concerned about the impact it would have on the value of my property. The value of our property is, they say, is determined by location. And the way it is presently, it's located with the neighboring property being undeveloped. I understand the zoning requires or permits certain uses for that property that, I have to accept that because that's just the way it is. I bought the property knowing that. However, with a variance, you're moving that warehouse closer to my property, which will impact the value of my property. And I'm here to try to preserve the equity that I have in that property.
Can you describe for the board, is the topography, what's the topography of that property as compared to yours? Is it a higher elevation than yours or lower?
The Lawrence property is higher in elevation than our property.
Is that true of the Shoal Estate property as well?
That maybe slightly. I'm not. I would have to look at an elevation map to be accurate about that.
But you're relatively familiar with the property to be developed, correct?
I am.
Okay. And do you know where the Lawrence property ends and the Shoal begins, or?
I do.
Okay. And the area that they're proposing to construct the warehouse, is it generally all uphill from where you are?
That would be correct.
And there's a stream that crosses that property.
There
Both of
is.
those properties, correct?
There is.
Is your farm reliant on that stream for the cattle that are grazed on it?
Not completely, but they certainly water from those streams.
Okay. And are there wetlands in the area where your property meets that, to your knowledge?
I think to the north of my property, there are designated wetlands.
Okay. Do you have concerns over the impacts from light generated by this proposed use?
Of course, yes.
Okay. And do you have concerns over noise generated by the proposed use?
Absolutely.
Can you be more specific as to what concerns you have about noise?
Well, the environment right now is relatively quiet with the exception of occasional noise out on Route 30. Truck traffic predominantly, maybe motorcycles from time to time you hear. So the neighborhood will be impacted with both noise, light, traffic. I'm concerned about that, but I'm mostly concerned about how that's going to impact the value of my property.
And you have made and your property is used as it is zoned, correct?
Correct.
And now the commercial portion is being used agriculturally as well, correct?
Correct.
Okay. And have you been here for the testimony of the applicant at the prior hearing?
I have been.
Okay. And are you concerned about whether or not the applicant will be able to comply as it is indicated it will do?
It's difficult for me to opine on that. However, I will say that the applicant represented himself as someone with vast amount of experience in development, including warehouses. And I find out tonight that that may not necessarily be the case, so that calls into question whether or not he'll be able to do what he says he's going to do.
Is there anything else that you wish the board to be aware of in terms of your opposition to the application?
Only with respect to, again, the evaluation, to the extent that the board might consider a variance to afford somebody a project which is going to make them money, it's going to come at the expense of valuation of my property. Doesn't seem right, doesn't seem fair to me.
And again, you're concerned that the farther the footprint of the building is pushed away from Route 30, the farther it is pushed towards your property itself.
That is correct, and every foot that it encroaches upon my property, I think is going to affect my value of my property. Who's going to want to buy an estate type property like ours with a warehouse smack dab as a neighbor.
And do you have a background in that involves finance or valuation at all?
Yes, I was a bank executive for many years and very familiar with property valuations and appraisals as we entertain loan values.
And were adjoining property uses considered in those valuations?
I'm not sure I understand that question.
Was the neighborhood or the uses of nearby proproperties
Oh,
taken into
absolutely. I didn't know if
consideration?
you specifically meant my property, but no, in the consideration and evaluation of properties, again, it comes down to location, 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 which is all about the neighborhood
Okay.
and the appeal of the neighborhood.
And just so that we can draw those two dots together, was it your experience that the intense uses adjacent to passive uses like agriculture had an effect on value?
Of course,
And was that value negative or positive?
it was adversely affected.
Okay. I have no other questions from Mr. Seibert. Offer him for cross.
Mr. Shudy?
Yes, Mr. Seibert, you mentioned that your property is subject to a conservation easement with the Adams County Farmland Conservation Board, is that correct?
The Land Conservancy of Adams
Land
County,
Conservancy. How much do you get paid for that?
$3,000 an acre.
$3,000 an acre?
Mhm.
And you own 200 acres?
Not, my wife and I own 150 acres. We put 150 acres in the Land Conservancy. The remaining 50 acres we purchased at a separate time. We put it in the names of along with ourselves, our daughter and son-in-law.
So,
And that was not put in the Land Conservancy.
and is the land that's in the Land Conservancy, is that the portions of the property that are located within the Agricultural Preservation Zoning District?
Yes, that would be correct.
Okay. And does that conservation easement prohibit you from subdividing your property?
It does.
Does that prohibit you from having additional residential dwellings on the property?
It does.
Does that prohibit you from basically doing anything but farming the property and maintaining the existing residential
Pretty much
development?
so, yes.
Okay. And just to be certain, you got paid then, I'm trying to do the math here quickly, about $450,000 for that?
Well, net, it was a little over 300.
Okay. And that's removing taxes for the
I'm
net.
trying to recall the tax impact, but I don't.
So you
I
got
don't know.
paid, you got paid $300,000.
Yes. Mhm.
Okay. And you mentioned that you were a bank executive. Did you have an appraiser come out to your property and tell you how much your property would be worth with or without the warehouse development next to you?
I did not.
Did you have in more to the point, did you have an appraiser come out and tell you the presumed devaluation of your property if the proposed warehouse is closer to the boundary line than further away from the boundary line? And how much that would change by the proximity to that northern boundary line?
No, but I wish I would.
Okay, but you don't have that information,
I
do
do
you?
not.
No. Okay. And so a lot of what you're talking about as far as losing value, it's kind of speculation and conjecture based upon what you've seen, correct?
Based upon experience.
Okay, but it's speculation. It's not concrete studies, correct?
I wouldn't call it speculation. I'd say it's pretty well-known facts that if you alter the character of the neighborhood for a property like mine, you're going to alter the value of the property.
Okay. But you are aware that the property, the subject property of this application is zoned commercial, correct?
I am.
Okay.
No arguments with that, just the variance.
Okay. You mentioned that you were concerned about the light impacts. Has your counsel provided you with a copy of the exhibit booklet that was provided? The exhibit booklet from the hearing in March.
No.
Okay, so you would not then be familiar with Exhibit 9, which is a complete lighting plan prepared by a professional engineer showing that the lighting does not go out onto other people. It does not extend beyond any of the property lines.
Actually, I'm going to object that's a mischaracterization of the testimony that was offered. The limited testimony that was offered says, and does this lighting plan as it relates to Lot 2 meet the standards required under the Township's lighting ordinance? Yes, it does. That's all that was testified to.
And, well, did you have an opportunity to review this plan? The
No.
lighting plan? Okay. And so I'm guessing you also did not have an opportunity to have any professional review that lighting plan either?
Correct.
Okay. So again, your concerns about lighting is also speculation and conjecture, especially since you did not review the lighting plan.
I did not review the lighting plan.
Okay. Okay. And you mentioned you had concerns over noise.
Correct.
Okay. And again, you mentioned that there's already noise due to the fact that there's commercial activity on Route 30.
From time to time, we will hear noise on Route 30.
Okay. And just to confirm, you do understand that the properties north of you are all zoned commercial, and you're within pretty close proximity to a commercial intersection.
You referred to Kralski's, Route
Yes.
30 and 94?
Yeah,
Correct.
Yes. Yes. And I have nothing further.
Redirect.
No.
Any cross-examination by the township? No, sir. Any questions by the board? I just have a question. So on, I think all the sketch plans, it says that your property is owned by Redding Rental Properties LLC. Who's that?
As far as I know, Redding Reynolds LLC purchased a property along Route 94 and intends to put mini storage units on that property.
Mr. Baranski, if it helps, the county tax mapper has the parcel at 3345 Carlisle Pike, which is the sort of L-shaped parcel.
Yep,
that
I see
is-
it.
That one is accurately designated. It is the property to the right that is inaccurately represented.
Okay. That's all I have. Does my question raise any questions by?
I
anyone?
think we can have a concurrence that there is a typo on the site plan as to the adjoining property owner as to Mr. Seibert's property.
Okay. Okay, that's it.
All right. Call Adam Snyder. All right. Can you state your name and spell your last name for the record and give us the address of the property that
Sure.
you own?
Adam Snyder. Last name is Snyder. Owner of Final Grade. Our address is 3390 Carlisle Pike, north of the Myers property.
When you refer to the Myers property, you actually do abut this property
In the corner.
in the corner between the Cross Keys Fellowship and the Myers. So it on the
Be touching about 100 feet.
if for the board's benefit on exhibit applicant's Exhibit 21. This is a property that if you are looking at lot number 1, it comes to a point on the north side that is adjacent to the Cross Keys Fellowship. Directly to the right, the property that is depicted there between that property line and Route 94 is Mr. Snyder's property. And, sir, how many acres do you have at 3390?
Approximately 9.
And you said you're the owner of Final Grade. What's Final Grade?
So we're a contracting company, outdoor contracting, excavation, landscaping, and tree service.
Okay, and do you operate that business from this property at 3390?
Correct.
Do you live there as well?
No, I do not.
Okay. Do you live within the township?
I live in Reading Township,
Okay,
so 10 minutes away.
okay. But you're on this property every day?
Correct. Well,
And-
Monday to Friday.
I
Try not to be Saturdays.
Gotcha. Can you tell the board, how long have you owned that property?
I moved in, I want to say about 4 years ago, 2020.
Okay.
We leased it for approximately a year and a half, 2 years, and then we bought. I believe it was 2022.
September of 2022?
Yep.
Okay. And how many employees do you have at that site?
The current time, 14, I believe.
Okay. And do you do operations on site there?
Correct.
What do you do on site?
So we have crews that come in and out of the site, park their vehicles there, and then go work. We're a service-based company, so we, start and end at the site.
At this
At
location?
that location,
So
correct.
employees report there in the morning, pick
Correct.
up equipment and materials, and go to client sites.
Correct.
Okay. So why are you here tonight in opposition? What is your concern?
Yeah, the main concern, we are, I use Google Earth, and we are 2,800 feet away from Cross Keys intersection is my driveway. And Monday through Friday, I would say most mornings at around 7 o'clock when we're pulling out of our location, it is backed up. The intersection is backed up to our property there to where we cannot pull out easily. If this were to go in, just using a really, really rough number of an extra 100 vehicles, tractor trailers, you're talking 54 feet of vehicle, that's 5,400 feet. Yes, that's extreme. That might be the worst case scenario, but you're talking a lot of distance added. The amount of traffic that tractor trailers add, and I own large vehicles. We pull large vehicles out on that road every day. It's not easy, especially making a left-hand turn. So
That would be going north on 94?
correct. I did the math on the distance between the proposed entrance from our entrance, and it's 1,000 feet. So even vehicles turning in and out of there, stopping, doing that is going to very much impact our business. Just the ease of pulling in and out of every day, morning and evening. We have a very moderate small business. We are service oriented, so we're community oriented. Our impact on the traffic there is minimal compared to you're talking 300 to 600 vehicles a day going in and out of there plus. So, and these are not small vehicles. So I see it as a very big detrimental effect on the local area of what obviously is going to impact my company, but everybody around us, all the residences and the businesses, it just doesn't fit. That size usage, the usage of what you're trying to do does not fit in that area.
And you're saying that there is already an existing problem with access to Route 94, and your concern is that it would exacerbate the existing condition.
It's already stressed. Adding this is going to push everything way over the limits. So yes, it's already stressed. It's not horrible. It's not the middle of Hanover right now or the middle of New York City, you know. It's urban area, but I mean, it's already at its peak. Anybody that lives around here that uses Cross Keys, it's not an easy road to go in and out and use the businesses that are around the Cross Keys area. So,
And I'll anticipate Mr. Schuette's question. It's not like you're a traffic engineer, correct?
I am not a traffic engineer. I drive big rigs. We have large vehicles. We know how hard it is to go in and out of those areas. But yeah, it's. I mean, a lot of this is common sense, guys. I know you. There are professionals. I'm a professional at something, so I understand there's professionals that do, estimations. But even professional estimations are just estimations. So you have to take it at a bird's eye view of what is this really going to do to this economy, to this area, to this local community. I venture to say, like, what is the good of this? What is this trying to do? What are we trying to accomplish here? What good for the community is this proposing, or is it just a way to make money?
Do you, in operating heavy equipment that leaves that site, are there conflicts with traffic as you're trying to accelerate out of your driveway and onto the road?
Like I said, it's at every point it's stressed right now. So any addition to what is right now, and we'll have it's a zone commercial area. You're going to have businesses move in and develop, but this is not just a normal usage or a normal business. This
Is there
a
anything
large
in
business.
is there anything in the immediate area that has the intensity of what is has been testified to already in terms of the intensity of heavy truck traffic?
No, this is there's nothing around the local area that is to this size and scope.
Okay. Do you have anything else that you want the board to be aware of in offering your objections?
There's areas around the area that this would be fine in. Look at Carlisle. There's whole industries built like this within a half an hour of this area that are actually suited for this usage. What this is going to do from Cross Keys to Route 15 is going to be disastrous. So I commute every day. My house is right off of that commute. So from traffic going from 94, Route 30, up 94 to 15, to use 83 and to use 81 and all those, it's gonna be a huge impact. So we would be foolish to see this as just another business going in. Now this is a huge, monstrous, Need I say more?
I have nothing further for Mr. Snyder. I'd offer him for cross.
Mr. Schuette?
Mr. Snyder, and I thank Mr. Wolf for asking the question that I would have asked. Nothing you testified to today is based upon any professional or expert knowledge of traffic conditions or traffic impacts, correct?
I am a professional driver. I'm a Class A professional driver, so I understand the impacts of what a Class A commercial rig does on the road, yes.
Okay. So your estimation of what's going to happen is conjecture and speculation based upon non-traffic engineering expertise, correct?
Correct.
I had to object to the characterization as speculation based on expertise. Or
Not
based on
not
his
based
experience.
not based on engineering
hold on. I get
expertise.
to overrule or sustain. I will overrule the objection.
Okay. I think you've also testified that there's an existing traffic congestion problem there, correct?
It's at its limits in some points of the day. Yep.
Okay. And you would agree that nevertheless, the subject property is still zoned for commercial development, correct?
Correct.
And that in being zoned for commercial development, that a warehouse use is a permitted use by special exception? Do you know that?
I mean, yes.
Okay. Is there anything specific about the warehouse use that has been testified to that makes it different than any other warehouse use that could occupy this space, that makes it worse in your opinion? Or would any warehouse use in this space cause the same problems?
Yeah, in my opinion, you're trying to cram 10 times the business into this size space that you have.
Okay,
If you were going to be 10 times smaller or 5 times smaller, it'd be reasonable. This is not reasonable.
is there anything about the size of the warehouse itself that violates the zoning ordinance that you know of?
The amount of trucks in and out of there, I think, does start to violate the area. I don't know if it violates the ordinance, but what it does to the area, yes, I think it does violate it.
But whether it's Gary's warehouse or, say, First Industrial's warehouse, would that make a difference in your estimation?
The size of it, yes.
Okay, if it's a 321 square foot warehouse that's permitted, which the ordinance permits, whether it's run by Gary, as testified to by Gary, or any other warehouse developer or operator, would that make a difference in your
I'm going
in
to
your
object.
estimation?
The standard is not who the operator is, and the witness has answered that he maintains that it's the
I'll
size
withdraw
of the
the, I'll withdraw the
facility.
question.
Yeah, I think that's been asked and answered.
I have nothing further.
Any cross by the township? Any questions by the board? Any redirect from Mr. Wolf?
Very brief. Mr. Snyder, are you familiar with the ordinance requirement that the applicant has to demonstrate that its truck or rail access and operation shall not conflict with the convenience and safety of vehicular traffic and parking? Were you aware that that's the requirement in the ordinance?
I am now.
Okay. Is it your opinion that the proposed use, based on the testimony that you've heard, will conflict with the convenience and safety of vehicular traffic and parking, based on your real-world experience, both operating heavy trucks and your experience and observations of the existing conditions on Carlisle Pike?
Yeah, I do. I was also at the meeting in March.
So you
where
heard the testimony?
I heard the testimony, I heard the traffic study, and I heard all the dealings then, and I think the main argument stands that this is too much and too big for this area. So yes, I understand that.
And so in that testimony, you heard that there were no improvements proposed to the roadway that would ameliorate or improve the existing conditions proposed as part of this application, correct?
Correct.
I have no other questions.
If
Does that, does that generate any questions for you, Mr. Shi?
Yes, just, I mean, yes, Mr. Snyder, there was testimony as to proposed improvement should this be approved, and those proposed improvements would be required by PennDOT. Did you not listen to that?
I was at the meeting.
Did you not see the proposed improvements being discussed?
Can you clarify what proposed improvements you're referring to? It's my understanding that the applicant wasn't doing any off-site proposed improvements, at least as of the revised traffic study that eliminated one right-hand turn lane.
I think Exhibit F shows all of the proposed improvements, but if you weren't here, you weren't here.
I think he was here.
Was here.
Yeah, but I mean, if Mr. Wolf wasn't here, he wasn't here.
I didn't see it in the transcript. That's why I'm asking.
Mr. Snyder was here, though.
Okay, but, okay, I have no further questions.
One more comment if I could.
No.
No?
And does that generate any cross for the township? Any questions by the board? Okay. Mr. Wolf?
Step down. All right. Chelsea Ross? All right, can you state your first and last name, spell your last name, and your address once you're sworn in?
Yep. I did. Chelsea Ross, and the last name is Ross.
And where do you live, Chelsea?
I live at 46 Woods Road in Abbottstown.
And what do you do for a living?
I drive a school bus
For whom?
for Kanawha Valley School District.
Okay. And where does your route take you?
Well, I have two different routes. I go into Abbottstown, I go down Racetrack Road, and then through Cross Keys. That's just my high school run.
So from Abbottstown, you come 30 west into Cross Keys? Do you turn onto 94 or do you continue straight through Cross Keys?
I go towards the Abbottstown Square. I come around, go down Racetrack Road. I come out of Bear Road, take it left towards Cross Keys, go through Cross Keys and into the Chinkapin development.
Okay. And
That's just my high school run. I have exactly 5 minutes from the time I drop off my high school run to get to Pine Run Road, which is out Berlin Road, left onto 94, and then right onto Pine Run Road.
okay. And do you go through Cross Keys again on that route?
Multiple times.
Okay. And these are for elementary or middle school students?
It's for CVIS, which is the intermediate school, 4th through 6th grade.
Okay. And so how many times in a given school day do you pass through the Cross Keys intersection?
10.
Okay. And so, that 5 in the morning, 5 in the evening, or in the afternoon? Okay. And so, you've heard some tests. Were you here at the hearing in March?
No.
Okay. Can you tell the board, however, what your experience with the amount of delays that you have at the Cross Keys intersection on a regular basis might be?
So a regular basis at 7 o'clock in the morning for my first run, I cannot get out of Bear Road to make a left. I obviously have to cross over the highway to head towards Cross Keys. Nobody is polite. Nobody lets you out. You don't get, you don't get the wave on. I sit there for 5 to 10 minutes now, just trying to get out to get to Cross Keys.
And you're making a left from traveling north on Bear Road, turning left onto 30
Yes.
in a westerly direction?
Yes.
Okay.
And then once I'm at Cross Keys, I always hit the light. But I am normally backed up to about Premier Auto at that time, which is where that Stanley Drive is.
So you're saying that the typical stacking that you're dealing with, it goes back to Stanley Drive as it is?
Already in the morning at 7 o'clock, absolutely.
Okay. And your testimony is that you can't get through Cross Keys on a single traffic phase?
No,
Okay. How, does it take more than one?
at least 3.
3 phases to get through?
Yep,
Okay. And do you turn right or do you go straight
I
through?
go straight.
Okay. And then you said that you come back through after dropping off your high schoolers?
I do to pick up my own children.
Okay. And then you do the elementary route.
Yes,
Okay. So in the course of going through there, do you see, is that congestion typical each weekday?
yes,
How about in the afternoon?
it's worse.
Okay. How, can you be more specific?
So in the afternoon, I have to come from Abbottstown, and and this is what the problem is going to be. I can see that the traffic is already backed up past Premier. So I take a right onto my own road,
Woods Drive.
Woods Road.
Woods Road, excuse me.
And then I have to go down Woods Road to get out to Pine Run Road, and I have to reroute just to be able to make time to get everybody home on time.
So is it fair to say that you have to already divert your route from going through Cross Keys in order to avoid the congestion that already exists at that intersection.
Yes, and I do that because our transportation lady at the school, if we are later than 5 minutes for any drop-off, we have to radio in. Every parent on my bus is notified that the bus is running 5 minutes behind. If I'm running 10 minutes behind, another email is sent out to every parent on my bus that I am running 10 minutes behind.
And are you frequently having to radio now to advise that you're late? How often would you?
Yes
I'm gonna
and
rephrase the
yes
question.
and no.
How frequently do you have to do that?
At least twice or 3 times a week.
Okay. Have you noticed how long have you been driving your school bus?
Since 2019.
Okay. Have you noticed an increase in traffic at the intersection in that time?
Yes.
Okay. And are you having to radio more frequently than you used to?
Yes and no, because I'm diverting already, which is going to be a problem because I live on Woods Road.
Okay.
And-
do you see other vehicles use Woods Road as a way to avoid
yeah.
cross keys?
Oh, yeah.
Do you see vehicles using Forest to avoid
Yes.
cross keys?
Yes.
And are you observing that as well from your house on Woods Road?
Yes.
How close are you to the intersection at Route 30?
I'm like hop, skip, and a jump.
Second or third, fourth, fifth house up from the intersection?
Yes, I'm the second. There are a line of houses that go along 30. I am the first house.
Behind those?
Yes.
Okay. And Woods Road is the first township road on the east side of the proposed development?
Yes.
Okay. Is there any, are you concerned about how much truck traffic do you encounter now on Route 30?
There's a lot. There's a pothole right at my road for us, and it's like a loud thump. I don't know what township. I think that's Berwick actually on that part. Have tried to fix it multiple times, but it doesn't work. It's just, they're tractor trailers. They're ruining the roads.
But are you dealing with congestion issues?
Yes.
Because of tractor trailer traffic already
Yes.
existing?
Yes.
Are you aware of the provision in the ordinance that requires the applicant to demonstrate that trucker rail access and operations would not conflict with the convenience and safety of vehicular traffic and parking?
No.
Are you aware of it now?
Yes.
And do you have any opinion from your experience of 5 years driving a school bus past the project site on a daily basis, twice a day, 5 days a week, as to whether or not the additional traffic that is proposed to be generated from this site is going to have a negative effect on convenience and safety?
It is going to have a big effect on safety to start with. I don't have a lot of property. I don't have a lot of money. I don't have any other reason other than these kids, reds are run every single day on a school bus. Tractor trailers are the main ones who run our reds. We stop on 30. They just keep flying by. Somebody is going to get hurt. Kids are going to get hurt. I live on Woods Road. This is going to be where through traffic goes. If you're coming from York Springs, you're not going to want to go to Cross Keys. You're going to come down Forest. You're going to make a right on Woods to come out to 30. There's a dance studio right across from me. There are kids outside running all the day. I have children. Cars already fly. People are going to be mad because they're late for work and they're going to cut through, fly through. Like, this is safety. I could care less about ordinances. I could care less about the money. It's about the safety. I also have a stop on 94. The girl's dad comes, like, he's about to come out with more than just himself. He's going to come out with a shotgun because these trucks irritate him so bad. They don't stop. She crosses over 94. These trucks do not stop. They do not stop. And if we report the drivers, nothing happens because we need to know what they're wearing, what they look like, their blood type, their social security number, and everything else for anything to happen.
I take it that's an exaggeration.
I really don't think so. We do need to know all of that. Probably not the blood type or the social security number, but that could probably help.
So, and again, I'm sure Mr. Schuette's going to ask you whether or not you're a traffic engineer.
I am
You're gonna
not.
say no.
Nope, I'm
But
definitely
you do
not.
have experience as a professional bus driver for the last 5 years, operating a school bus daily through the project area where it fronts on both 94 and on 30, correct?
Yes.
And based on your real-world experience, do you believe that there is going to be an adverse impact on the ability for you to safely operate your bus in the area of this proposed site?
110%, yes.
I have no other questions for Ms. Ross. I offer her for cross.
Mr. Schuette.
Hi.
Just so I understand, your concerns are generated by an existing congestion of cars and trucks on the roads near the subject property.
If you're missing the point of the story, yes.
I just wanted to be sure. Just want to be sure. But all the concerns you've raised are due to existing conditions, correct?
Yes.
Okay. Have you reviewed any? You were not at the hearing in March.
No.
Okay. And have you reviewed any portion of the traffic study or any portion of the traffic study specific to the improvements that the developer is proposing to make?
Okay, so I had already said that I wasn't at the meeting. I
Right.
do understand your point, but you're not understanding mine.
I didn't ask about that. I wanted my only question is: did you review any of the proposed improvements set forth in
No,
the traffic
I had
study?
already stated that is not my concern. My
Okay.
concern is safety.
Okay, I have no further questions.
Good.
Cool.
Easy. I get it. Believe me.
Any cross-exam by the township? Any questions by the board? Any redirect, Mr. Wolf?
No.
Okay. That's it.
You're good to go. Thank you. With that for tonight, if I can have 1 second.
I can be done if you can be done. I can be done.
I will ask, I'm going to reserve the ability for Ms. Ross to come back to testify after Mr. Schick testifies tomorrow night as to the revised study, to make sure that there's no, that if she wishes to supplement her testimony, that we can do that.
Sure.
And with that, I would suggest that we open it to public comment in the time that we have left, and reserve the ability to call additional objectors tomorrow evening. I believe we're at 10 o'clock, 10:05.
Okay, you fine with that?
I would say it's 5 after 10. Why don't we just?
Well, if
I
we-
think the extent to which we will have public comment that there aren't already parties. Why don't we just stick with the traditional way and do it at the end of the testimony?
I
tomorrow
have a
night?
concern that we had indicated to people tonight that they would be able to do
Yeah,
that.
I said we would, if we had
Okay.
time left till 10:30, we have
That's fine.
25
Yeah.
minutes. Anybody from the public that would like to give a comment, either in favor of or in opposition to the application, please come to the pedestal mic. You'll have to give your name and address and be sworn in by the stenographer. And what we're going to try to avoid is repetitive comments. So if we get the first 5 are all about traffic, we don't need a 6th. Yes, sir. Go ahead. Is that mic on? I don't think we've used it. Okay, there you go.
See towards the middle when he's finished.
I do. Dan Devaney, 710 Tapeworm Road, New Oxford, Diviney.
Go ahead, Mr. Devaney.
Okay, I was at the last hearing, and so I've heard 3 expert testimonies. actually more than that. But the first expert testimony I heard was from the fellow that did the traffic studies, and he took at least a full 5 minutes to give his background and all his degrees and his experience. And then he said that this will not impact the community. It'll have no impact on the community. And then I heard some other people who have no engineering degrees. The bus driver and several other people gave what I consider expert testimony. Is based on real life. It's what they experienced. It's factual. It's not a study done with strips over the road at certain times. So I place a lot of value on that. I'm against the warehouse because the traffic backs up, and I go through Cross Keys a lot, and I'll go through 2-3 light cycles. It'll back up the whole way to Forest Drive. It'll back up the whole way to Brickyard or Brick Crafters Road. And this is going to, it's more than what the roads can handle. The improvements that were mentioned was just extending the left-hand turn on 94 going south. And that's not going to make much of a dent in anything with the problems that we currently have. And then adding a couple hundred trucks, it's just not going to help. People are going to bypass Cross Keys. They're going to be going through New Oxford. They're going to be going on all these side roads that aren't built for heavy tractor trailer traffic or for a lot of cars. Or people are going to be flying. The truck drivers are going to be upset coming in and out of the distribution center, and they're going to be making mistakes driving because they're going to be upset with the traffic jams. That's the only comments I have, and I'm not for it.
Thank you. Anybody else? Come on. Name and address and be sworn in, please.
Sorry, wrong hand. I sure do. My name is Susie Armacost, and I live at 1830 Storm Store Road, and we're farmers. We have a lot of tractors, farm equipment. We're out on the road, and we don't need all this traffic. We can't get out on 94 now from Berlin Road. If you want to turn left, you can't go left. You have to sit there. My other problem is the environment, the wetlands and the streams, the impact that it'll have on that, the wildlife that you're going to disrupt with your building. You're going to get $1 million in your pocket, but you're going to kill all the wildlife. Crime. The people in these warehouses, I've worked at Amazon, I've worked at Chewy. The people in these warehouses are not always up to snuff. And these people, they'll be on people's property, they'll be stealing from the man next door that has a landscape business, they'll be taking stuff out of the people that work for him out of their cars, they'll be breaking into stuff. They just are not people that you want to have next door to you. It's going to ruin people's property values. I don't care what study you do or who you ask. It's going to ruin people's property values. You're going to have traffic going down all these back roads, avoiding Cross Keys, and they're going to go wherever they can to make time to go where they're going. This is idiocy. This town is a small town, and that's one of the reasons why I love it, why I came here. I've been here a little over a decade, but I really like it. The antique shops, the people, the small eateries, the circle. All these tractor trailers going through the circle. What is this? And we have Amish moving here. The Amish and their carriages and the horses and the kids in these carriages, and you have accidents with these kids. And the school buses. She's correct. The back roads, noise. All the noise from these trucks. It's bad enough now when you can hear things on 30, the sirens and the fire trucks and the tractor trailers and the air pollution from these trucks. These guys, they idle their trucks longer than 5 minutes. I have my CDL. I've driven trucks all over the place, and I've worked at Amazon. I know what they do with their trucks, and they're not going to park them where you tell them to. They're going to park wherever they want to. They're going to have trucks everywhere. It's just not going to be safe. The Brethren Home. Has anybody thought about the people at the Brethren Home? What about all these old people? What are they supposed to do with all these tractor trailers and all these people going in and out of the warehouses? You know, they have a hard enough time negotiating, driving now. This is not fair. This is somebody thinking of themselves and lining their own pockets, and they don't think about the people that live in the small town. This is a nice little town. Why do this? Take this stuff closer to 15, where there are still some open fields and somebody will sell you their field for $1 million or whatever, and take it over there where your trucks can go on 15 and go whatever direction they want to go. That's where all the traffic is anyway. And this affects the entire town. This doesn't just affect, somebody living next door to the warehouse. This affects everybody in New Oxford. It doesn't just affect the people that are living across the street or who have to go to work in the morning. It affects the whole town. This has the small town feeling, and it has the small town everything. It's just not the way it's supposed to be. Nobody moved here to have to negotiate warehouse. It's warehouse will change this place, and it will not be for the better. It just won't. Yeah, these people are selfish. They're very selfish for wanting to do this. They're very selfish they're thinking of themselves. They're not thinking about the people who live in New Oxford. They're thinking about what they're going to make off of this deal. That's what it is. It's a deal. It's not our deal. It's their deal. This man is all tan. He's been on his boat for a month.
No personal attacks. Just keep it to the facts.
Shh. Yeah. Well, and we can't get out, and we have a little farm on Hanover Street too. We bale hay at 8 or 9 different little farms and different pieces of property. So we can't even get out on Hanover Street from this one property if you're there at 3 o'clock or 3:30 in the afternoon. And then we're going to have more trucks. This is insane. And then the other thing is, on Storm Store Road where we have our other farm, the kids and people are going down that road so fast now. If they're trying to go around 30 and they're going to be coming down that road, there's a development next to us and the school buses, and the kids are playing out on the sidewalks, and their balls roll out in the road, and the motorcycles are going 100 miles an hour now. What are they going to do if they're late for work and they're going to use our road to go around and try to go around the traffic?
Okay,
That's
we
all.
have to get somebody else.
Yeah.
Thank you.
Well,
Anybody else? Name and address and get sworn in, please.
My name is Carl Peterzak. I live at 63 Hunters Trail in Gettysburg. Yes, I do. So I'm here in my role as president of Destination Gettysburg. We're the tourism agency for all of Adams County. And this is mainly about traffic again, but throughout all of Adams County, we already have far too many tractor trailers driving our back roads to get to the highways in 81 and 15 and 83. And the traffic study done by the applicant shows 400 tractor trailers, if I have my information correct, 400 trucks on the road, plus, I don't know, hundreds of cars from employees. I can't stand on the square in Gettysburg and have a conversation with somebody because of all the trucks already rolling through the square every 10 seconds Adding 400 more trucks, even if only a quarter of those maybe go west towards Gettysburg to get on 81 or 15, that would make it even more difficult. It's dangerous. I've seen visitors almost getting run over by trucks in the square because they'll just come barreling through and not be more patient like most residents. The historic buildings in Adams County that were built in the 1800s, a lot of them are crumbling just from the vibrations of the trucks rolling through as it is now. So that would only get worse. So I'm in opposition to this from that standpoint, from representing visitors as well as residents in Adams County. Thank you.
Thank you. Anyone else? Give your name and address to the stenographer and be sworn in, please.
Very good. Bill Popovich, 36 Franklin Drive in McSherrystown. So, I do. I've been in McSherrystown now going on 7 years. And in that 7 years, I've watched this region absolutely under siege. We are being overrun with development, overrun with highways, overrun with everything under the sun. The 9430 intersection, my beloved friends at PennDOT will give me a 1,000-page document saying, this is our traffic study. And the way it works at PennDOT, yeah, the traffic's going to be really bad, and that's just tough. So I'm sick of it. So we watched massive developments everywhere in the region. They're everywhere. Pick a township, West Manheim, or we live nearby in Hanover, and there's been green spaces that were farmland when we got here in 2018. Totally overrun, and now there are massive overdevelopments. The traffic in the region is gridlocked now. It is gridlocked now. Anybody disagree with that? So we live in gridlock, and now we're going to add more. This particular event, putting mega warehouses at this intersection, that will paralyze that intersection. And that will wreck the entire region all by itself. We got lots of other things going wrong. My beloved friends from Utz, I live 500 yards from their main plant. They just put a mega warehouse in there. They didn't tell anybody about it. I didn't know about it. They were very, very quiet. So 4 or 5 years ago, my beloved friends at Conewago Township were going, well, something's going to go on at Utz, and they're going to build a big parking lot. Well, the big parking lot turned out to be a really big parking lot with an extremely big, gigantic warehouse on it. So now I have a mega warehouse right down the street. And there's mega warehouses all over the place. On Bletner Avenue out in Hanover, the food company, they put in a warehouse. The thing has to be 1,000, 1,200 feet from end to end. So I hear the technicalese, especially from attorneys, going, just because we're adding more traffic doesn't mean you can turn us down. Well, I've heard that 100 times already at Conewago Township. Now we're gridlocked. I'll listen to this bus driver. You ought to see what the bus drivers have to do in the rest of Hanover or anywhere in the region. So it's on, the supervisors in this town. We all have to suffer with what's already going on at 94 and 30. It's disgusting. I don't care who wants to move in there. You're going to put mega warehousing in there. It will paralyze the intersection. And traffic study, I don't care how many civil engineers with PE in front of their name, it will paralyze the intersection. What else do we need to know? Do you really want to paralyze that intersection and make the entire region even worse than it is now? It's hell living here. We moved here 6 or 7 years ago because we like the quality of life. It's already hanging by a thread. You've had lots of testimony and all these folks who live nearby this thing. It would be absolutely a moral outrage for a supine body to say, oh, Mr. Developer, we'll give you what you want because you've checked all the boxes.
Anyone else? Name and
Hi,
address.
I'm Randy Myers. I live in 41 Oxford Drive in New Oxford. I do. I do. Randy Myers. Oh, 41 Oxford Drive. Yeah. Okay, I have a big concern with the traffic out there it's going to be with the warehouse. I know they did a study on it, but I don't think the study was done the way it properly should have been done, because it's not the same every day. I work for a couple towing companies on the side, and we're constantly around Cross Keys area, 94 area, 30 area, and I go through that area all day long. And it's not safe. And the way they want to do the study for the truckers to come out of that road onto 94, if you want to put 2 lanes in, you're going to have cars in and out, trucks changing lanes constantly, and it's going to be nothing but more accidents. I can just see it. So I'm sure that wasn't in a study. I've been along the road a couple times. I know one time I was up on 15. I had a tractor trailer drive by me when I was loading up. Almost took me out. I could feel the air right on my back. They don't stop. They will not slow up. And the law is move over. And no one does, whether it's a truck or a car. So I'm actually against it, because it's no way they're going to keep after the trucks changing lanes, the cars changing lanes in front of each other. Just not going to be safe.
Okay,
That's all I have to say.
thank you.
Yep.
Anyone else? We have 7 minutes. Yes, sir. Name and address, get sworn in.
Jim Lafferty, New Oxford. 145 Matthew Drive. I certainly do. I'm going to be quick. I've heard a lot of things up here tonight. Safety, traffic, property value, everything else. But Daddy taught me one thing when I was little. He says, son, keep in mind, money talks, BS walks.
Anybody else? Last call. I recognize this man.
I think I'm already sworn in.
You're still under oath, sir.
I'm still under oath. So I just want to remind the board.
Remind
that-
us who you are.
What's that?
Give us your name again.
Jeff Seibert.
Seibert, that's right.
That this safety concern is not just a theoretical issue. We live on Forest Drive, and shortly after we moved here, our neighbor was mowing his lawn, and he pulled out mowing along the edge of the road, got run over by a truck, killed. It's not just a theoretical issue. The more traffic and pressure you put on the ancillary roads, and this will put more traffic on Forest Drive, Woods Road, because they're going to, this is already mentioned, they're going to want to get around avoiding the traffic. Every time I mow my grass along Forest Drive, I think about my neighbor getting run over by a truck. It's not just a theoretical issue, it's real.
Last call. Going once? Nope. Come on down. Name and address, get sworn in.
Jerry Thurston, 4416 Carlisle Pike. I know you didn't want repetition of everything that's been said tonight. I live on Carlisle Pike, just south of Dick's Dam Road. I'm not an expert, but I experience it every day. I can hardly get out of my driveway safely now with the trucks that come down there and the cars, not just the trucks, but the volume of traffic. Now, the honorable attorney said at the very beginning of his presentation back in March, the increase in the volume of traffic is not a legitimate reason for declining the application. But how about how it impacts our life? You've heard from the people that talked before. The safety is in peril. Our health is in peril. Everything is in peril with this mega warehouse. And the traffic study said it was going to increase by 2,400 vehicles a day. Do you know how that's going to impact my driveway? I'll never get out of my house. I just want you to take this into consideration, the health, the welfare, and the safety of the residents in this area. It's your responsibility to make this decision. So please, think on it carefully and try to make the correct decision, whichever one it is. I'm not telling you what to do. I'm just telling you how it is. Thank you.
Good. Last call. All right, we're going to recess this meeting till tomorrow, same time, 6 p.m. here. Mostly going to be about traffic.